Lovely, thank you. Okay, good morning, everyone. It's now 9:30, so we'll make a start, please. My name's Christopher Warren. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division, the DPEA, and I was appointed by Scottish ministers to hold an inquiry into the Section 36 application for the Sanquhar 2 wind farm. So, following on from the fourth National Planning Framework, so NPF4 being laid before Parliament in November 2022, Scottish ministers decided that the inquiry into this and a number of other Section 36 applications should be reopened. So in this case, this of course follows on from the inquiry that was held in October 2021. You'll no doubt be aware that in March of last year, I submitted my report to ministers, which included a recommendation on whether or not consent should be granted. I obviously can't disclose what my recommendation was today. I have been asked to submit some supplementary report which takes account of NPF4, and in doing so, I'll be considering whether I stand by my previous recommendation. In the procedure notice that I issued on the 30th of November, I outlined that I wish to hold a further policy hearing session on the matter of NPF4 and the revised onshore wind policy statement, if published, and parties were advised of the publication of that document on the 21st of December. So by way of an update, NPF4 was approved by Parliament on the 11th of January. A letter from the Scottish Government's Chief Planner was published on the 16th of January, which outlines the next steps. So that outlines that the intention is that Scottish ministers will adopt and publish NPF4 on the 13th of February at 9 AM, meaning that it'll be in force and National Planning Framework 3 and Scottish Planning Policy will be superseded from that date and time. So assuming that goes ahead as planned, that'll be the policy context in which I'll be writing my supplementary report. So before I go any further, first of all, can I check that you can all hear me clearly? Just tell me if you can't. Great. And a few housekeeping points before I say a little bit more about how we'll progress today. So please keep your cameras turned on, except during any breaks. But please keep your microphone muted unless you're speaking, because otherwise we get feedback. Observers should keep their microphones and cameras turned off, please. If you wish to interject at any point, please raise your hand. But if I miss you, then please turn on your microphone to get my attention. And any phones nearby should be on silent if possible, please. Now, if there are any IT problems, I hope I'm not jinxing it, during the course of the hearing, please let me know if you're able to, but Ewan's keeping an eye on it for us too as well, so we've got some IT support on hand. Okay, so as with the previous inquiry and hearing sessions that we held, this hearing has been live streamed on the DPA webcast site, and a recording of it will also be available to be viewed there. So by participating today, you're consenting to the recording, storage and use of this material for webcasting, for training, and for the keeping of records that are accessible by the public. I'd like to thank you all for fitting this session into your busy diaries at kind of relatively short notice, and for meeting the deadline that I set for hearing statements as well. It is appreciated. I know who I'm expecting to be participating in this session, but could I ask you to introduce yourselves, please? And I'll start with the applicant, please.
Yes, good morning. So David Hardy. Hello, good morning. So partner in CMS, and I have David Bell to my left. Mr. Bell.
Yes, good morning. David Bell, Chartered Town Planner. I'll be giving the policy evidence for the applicant. Thank you.
Thank you. And for the council, please. Mr. Armstrong, you're on mute. We all do it.
Morning, sir. Douglas Armstrong here, member of the Faculty of Advocates, and I'm appearing for the council, instructed by Laura Whitelaw, solicitor, and with me today is Chris McTeer for the council. And Andrew Robinson is no longer with the council and has gone to become an inspector in England.
Okay, there we go.
So Chris McTeer has come in because he's obviously involved in a number of other wind turbine cases where there are similar hearings, and he has adopted Andrew Robinson's evidence as set out in his statement.
Thank you. And Mr. McTiggert, was it yourself that was on the site inspection?
Yes, sir, it was. Yep, I got very back along with you.
Good morning. Thank you.
Morning.
Okay, and then for Stop Sanquhar 2, please.
So good morning, I'm John Campbell. I'm a King's Counsel at Scottish Bar, representing Stop Sanquhar 2, SS2, and with me today is Dr. Chris Ford, who gave evidence on the previous occasion. On the top left of my screen, I don't know which.
Thank you. Good morning, both. Thank you.
Good morning, anyway.
Morning. For the airport, now I'm aware Mr. Brown, Ewan Brown will be joining us at 10:30, all being well. Is there anybody on the line who's here on behalf of the airport currently?
Yes, sir. My name is Fiona McGregor and I'm a solicitor at Denton's. I am holding fort until Mr. Brown is free of his court commitment.
Great. Good morning. Thank you. And is there anybody else on the line who was expecting to be participating, but I wasn't expecting? No. Okay, great. So the format of the session will be a discussion that I'll lead, structured around the agenda which was circulated last week. Do you all have sight of that? Or able to get sight? If not, yeah, good.
Yeah.
So it may be helpful if you have NPF4, the onshore wind policy statement, the LDP and others hearing statements easily to hand or open on your screens as we progress. So I'll be inviting particular people to contribute at appropriate times, but I'd welcome relevant comments and questions from any participant as the discussion progresses. I would ask, however, that if you have questions, these should be put through me, please. I'll say when I want to move on, or if I don't want to spend time on certain matters. I'm conscious we'll be covering some similar ground to what we've previously covered in some respects. Now we have the whole day set aside, but I think it's unlikely that we'll need the full day, but we'll wait and see. We'll take a break midway through the morning, and if we need to break for lunch, we'll do so at a convenient point, starting between around 12:30 and 1 PM for an hour. Is everyone clear about what I've outlined? Yeah, good. So does anyone have any questions or have any other matters they wish to raise before we launch into some questions? No? Okay, so moving straight on then on to item 2 on the agenda, and this is where I want to focus on the content of NPF4 specifically. Now, the logical starting point seems to me to be the spatial strategy and the spatial principles which effectively kind of set the scene and the basis for the policy approach contained in NPF4. So I'd like to begin by drawing out what you consider to be the overarching thrust of NPF4 insofar as it's relevant to Sanquhar 2. And as part of this, I'd like to explore what the spatial principle of a just transition might mean in practice. So with that in mind, Mr. Bell, perhaps I could ask you to get us started, just focusing for now on what is kind of new or noteworthy about NPF4's spatial strategy and principles compared to NPF3 or an SBP, for example.
Thank you. Good morning. Yes, I think we will come on to some of the specific differences with SPP in the context of some of the policies further down the agenda. But I think it's clear that the Scottish Government has delivered what it intended in terms of providing a rebalanced planning system, which places net zero, the climate crisis and the energy, the climate crisis and the nature crisis as the sort of key principles, the founding principles behind it, and that these are now reflected or to be reflected in all decisions. Allied with NPF4, the onshore wind policy statement delivers on the technology drive for onshore wind. We knew in the draft NPF4 that onshore wind was to be prominent in terms of the technologies to deliver, and that was shown to be the case in the documents. So the drive to net zero is very strong. There are, of course, balancing considerations that need to be borne in mind in terms of the policy approach. But before getting into the details, which will come later on the agenda, in terms of the just transition, which is the first matter on the agenda, one of the documents for the inquiry that helps understand that is CD 8.15, which is the draft energy strategy and just transition plan. And when that is viewed in the round, it's a lengthy document, but there are one or two references which I will give you for the note. One is on page 2, there is reference to economic opportunities and a just transition. Page 2 of the document refers to the fastest possible just transition from the oil and gas sector. So it's quite clear in the draft energy strategy that the government is taking a policy approach that will move very fast as possible from oil and gas to renewables. And one of the issues in doing so is the matter of jobs, reskilling, and spreading benefits. And that is a key part of the just transition. And one other reference, the final one I would make in terms of the energy strategy, is page 9, references hydrogen as an emerging sector where they say it's perfectly placed to support a just transition for the oil and gas workforces. Now, the question I think is important as well, what role does onshore wind have in the just transition? Well, in NPF4, on page 4, which is the specific point of this first agenda item, the first spatial principle of NPF4 is the just transition to net zero, and that be fair and inclusive. Now, of course, that applies to all development, whether it's house building, retailing, industrial development, or renewables. So it's a high-level spatial principle. But we know, and we'll come on to it, that onshore wind electricity generation over 50 megawatts is nationally important for the spatial strategy. And just finish on this point. The second document that I think is important in understanding what the government intends by the just transition in relation to onshore wind is in the onshore wind policy statement, which is CD 8.014. And I'll just pick out one or two references which are helpful in understanding that concept of just transition for this land use type. So if we go to paragraph 1.3.3 in the onshore wind policy statement, it says the ambition, and that's the 20 gigawatt onshore wind target. This ambition will help support the rapid decarbonisation of our energy system and the sectors that depend upon it, as well as aligning with a just transition to net zero, whilst other technologies reach maturity. So there's a recognition onshore wind is a mature, low-cost technology. We see that in the ministerial forward of the OWPS that can contribute to the cost of living crisis and energy security driven by primarily Russia's war in Ukraine. That is all referenced in that context. The second reference in the onshore wind policy statement is paragraph 2.4.7, where the government says it is crucial that the principles of a just transition are actively applied across the sector and that the benefits of the increased deployment of onshore wind are felt by all of Scotland's citizens, especially in the communities post-development. Now, what is clear, there's other references in the onshore wind policy statement, but I'll call a halt shortly to let others come in. But the applicant has responded positively to this, and if you recall, at the last policy session, there was reference to certainly the community benefit being offered of £2,500 per megawatt. The applicant is now increasing that to £5,000 per megawatt, and is also proposing that an energy fund be established, similar to the one they are progressing in East Lothian, which directs funding support to vulnerable households in terms of fuel poverty. So the applicant is stepping up in response to this very new policy emphasis to provide a commitment in that regard. But overall, it is considered that the proposed development would contribute positively to a just transition in a number of respects. Thank you.
Thank you, Mr. Bell. I'll open it up in a moment. We'll come back to the £5,000 per megawatt point later on. I think that'll fit better later in relation to policy 11. Just before I open it up, so in terms of the just transition being achieved, is that something which need for individual development proposals to kind of consider, or is that a wider kind of spatial principle that is essentially the outcome of NPF4 and other associated documents, that which it is essentially a product of multiple developments taking place?
I think it's certainly referenced in Policy 11 as one of the criteria that we will come to. But I think an important point is that this is not a 15 megawatt project, and there'll be a range of small projects that will collectively contribute. But it's one that, because of its scale, that it can make a highly material impact in the near term to that transition. And that links again to the express direction for decision makers to look at the contribution that a development would make in Policy 11, and it also links to the recognition that it's national developments that will deliver the spatial strategy in particular, i.e. developments of scale.
Thank you. Yeah, so we'll come back to Policy 11 in a fair bit more detail. I'd like to hear other people's views on what I asked and also what Mr. Bell has outlined. I'm sure there are some different views at the table. For the council, I don't. Mr. Armstrong, should I come to you first, or Mr. McTeer?
I think if we start with Mr. McTeer on this one, and I think he was planning just to go through the relevant references in the NPF dealing with just transition and give sort of comments on them rather than going into other documents at this stage that we're obviously going to look at as we go through your agenda. So we were going to concentrate on the point you set out in the for this section of the discussion. So I think he was going to start on page 4. So if we have the sort of NPF to hand.
Yes, thank you. Can you hear me okay?
Yes, thank you.
Okay, right. That's. So yeah, for our part, we're looking at the spatial principles, which we feel to be in the main about people and places. The NPF itself, actually, if I could just go back to page 3, where it says how we can make sustainable use of our natural assets in a way which benefits communities. That's people and places. The very spatial principle for just transition, where it says we will empower people to shape their places and to ensure the transition to net zero is fair and inclusive. We do consider that to be a key sort of point. One thing I would look at on page 4, where we're looking to apply these principles in practice, which gives us a starting point for how to apply these. And the ambition certainly in NPF4 is that we want our future places to work for everyone. And rather than compromise or trade-off between environmental, social and economic objectives, the strategy to bring together cross-cutting priorities and to achieve sustainable development. Now, as well as looking at the cross-cutting priorities, and I know Mr. Bell alluded to several other documents as well, which we'll come to later on, but it certainly seems to us to be looking at NPF4, the onshore wind policy statement, the energy strategy as a whole, and the sort of the spatial principles kind of flow through them all. Table 1 on page 5 of NPS, the first spatial principle there is the just transition, and that's seems to cover sustainable places again. So we're looking at that. If you look at the sort of the policy links to that as well, it covers a multitude of different policies, as well as tackling the nature and climate crisis. We're looking at biodiversity, natural places, and energy, just to name a few from that. So looking at sustainable places on page 6, and again, I'll just the policy links there to the energy strategy. So halfway down the sort of second side of text there, and what we also have is the interplay between land and sea will be critical given the scale of offshore renewable energy resources as well, which is something that we'll probably come to later on. I know we are looking at an onshore development, but in the sort of the wider energy strategy, there is quite an emphasis on offshore wind as well as onshore. Page 7 of NPF4, where we're looking at the national spatial strategy, right in at the very beginning, where we're looking at Scotland's future places. Again, the emphasis on place with that one. Future places will be net zero, nature positive, that are designed to reduce emissions and adapt to the impacts of climate change while protecting, recovering and restoring our environment. So protection of the environment is key there. The next paragraph down, the final sentence there, this means ensuring the right development happens in the right place. And moving on from that, the NPF has the encouragement of low carbon design, energy efficiency development that is accessible by sustainable travel, and the expansion of renewable energy generation. Now that's a wider ambition to have renewable energy in the mix, so to speak, and the just transition, which is mentioned after that, gives us the journey towards net zero society, which again we are looking at. It seems fair to everyone. So again, it links back to people as well with that one. So yeah, I think I'll.
Sorry to interrupt you mid-flow. Going back to the point you mentioned there about just in terms of the right development in the right place that you mentioned. What should be taken from that wording? You know, does that maintain the emphasis about outgoing policy, or is it possible for the NPF4 policies which follow that statement to kind of alter what may now be considered to be the right development, or what it might mean to be the right place, or both? What are your thoughts on that?
I suppose that there is a nod to outgoing policy in terms of the SPP. I mean, the SPP was very much focused on the right development and in the right place. And I suppose in the wider sense of things, and it is the national planning framework. And I know there could be a discussion around how much planning plays a part in this. So planning 101, if I can recall back from my time at university, was about the right development in the right place. So appreciating that the NPF covers planning for everything. It doesn't just cover the development that we're looking at just now. It has to cover everything else. So Yeah, I think it's still about place-based planning. And again, if I can kind of go back to what I was looking at, or what I was,
I
mentioned
did
before.
cut you off. Yeah, sorry.
That's fine. Again, as I say, it's about people and places. So I suppose right development in the right place is all about placemaking for that. So on page 7, just when we're looking at national developments, for strategic renewable energy generation, one of the sort of the key factors that we see there is providing employment opportunity for communities and helping reduce emissions, improve the security of supply. And again, if you look to page 8, it kind of gives you all the sort of the cross-cutting outcomes and policy links as well. So there are a sort of multitude of different policies which need to be taken into account, which I'm guessing we'll go on to in later on in the session for that. But for the moment, that's me just now. If unless Douglas has got anything else to add to that.
Yes, sir.
Thank you, Mr. McTeer. So, the stock Sanquhar 2. So the question I asked was around kind of what you consider to be kind of new or different about NPF4. And you've heard what the applicant and council have said. I'd like your take on it, please.
Yes, sir. Good morning. I'm going to introduce Dr. Ford, who will speak to this question, I think.
Thank you.
Good morning, sir.
Morning.
Yeah, obviously the just transition is a relatively new thing overall. I mean, we've had national planning framework for many years, over a decade or so. But just transition is relatively new, coming in the last couple of years. So there is a sense in which we are still adopting and understanding what it means and adopting it and bringing it into policy. So I do think we're at an embryonic stage with it, rather than anything that's formed and closely defined. But of the two presentations that I've heard so far, Mr. Bell is talking about climate change and that perspective. But to me, Mr. McTeer seems to have got it right. If you look at the wording on page 4 of the NPF4 itself, it is about people and places, the just transition. That's primarily what the focus is. And it's about being fair and inclusive. That's the other key phrase in the whole just transition emphasis within NPF4. So it's about, if you like, the social side to development. And it's something that is tacitly considered by planning and the planning system. But the just transition is bringing it more explicitly into the planning system. And as I said, because it's relatively new, I suspect we're still learning what this really means. But it is, you asked the question slightly earlier on about is about individual developments or is it about general principles? I think if you go to the wording itself, it talks about people shaping their places. That is obviously people living in a particular area, shaping that particular area. So my interpretation is that actually it's about individual developments, not just the general principle. And then when you move on to look at those individual implications of this particular proposal, for example, it means that you have to look at, Mr. Bell's mentioned community benefit, and we'll obviously come back to that later on. Another thing that I think we'll come back to later on is the net economic benefit of the proposal. So I won't dwell on those particular points there. But another thing that is part of the spatial principles is the rural revitalisation. And there's been previous discussions on this proposal about the loss of population, the depopulation in the area as a direct consequence of the applicant's actions. That is obviously not something which is contributing towards a just transition. So you do have to look at individual proposals, and I think we may find more policy directives, informal policy directives coming about what this means as we fully bring the just transition into the planning system. But at this moment in time, it's about the people and the places. And obviously, you have to consider the impact of the proposal on the people immediately already resident there. So that's my emphasis in terms of the just transition. And to be frank, I'm not sure, in part because of the policy shift and that has taken place and the length of time that this application's been undecided and live. I'm not sure that this proposal has fully taken account of the just transition and the implications for the just transition. Thank you.
Thank you. And in terms of the question that I asked Mr. McTeer, I'll perhaps come back to the applicant as well on this point, is around that point around the right development in the right place. And the question I asked Mr. McTeer was around, can that change with policy? So in terms of what is the right development or what is the right place, does that alter depending on what the policy which then follows sets out?
Does that bring address to me or Mr. Bell?
Yes, please. Thank you. Sorry.
I think the answer is it is about individual cases being decided. We get policy direction and guidance in a sense of how policy should be read, but at the end of the day, it's about measuring the individual cases, and it's a case-specific judgment, in my view.
Thank you. Before I revert to the applicant, I should just check, does in terms of the airport's contribution here, would you like to add anything here? I appreciate it's not the focus of your hearing statement.
No, thank you, sir. We have nothing to add.
No problem. Okay, thank you. So, Mr. Bell or Mr. Hardy, you've kind of heard what's been said there and what I've asked. Do you have any comments or reflections on that, please?
Yes, thank you. In terms of your question, does NPF4 change what may be considered to be the right development in the right place? I think absolutely it does. And that is expressly clear in a number of policy areas which have changed. To give you one example, wildland, although that is not a matter that is engaged in this case, the explanatory report that goes along with NPF4 makes it clear that the government has changed the policy in relation to wildland, otherwise the targets will not be met. So there has been an express watering down of the protection in relation to wildland, where renewable energy developments are now expressly allowed within wildland areas subject to assessments. And the government has said that if a development is out with a wildland area, then the effects on that area are not a significant consideration. So that is a very clear policy change with an objective in mind to allow more renewable energy development. Another change is the spatial framework approach has gone, and beyond national parks and national scenic areas, developments are to be supported in principle. Third change is in relation to local landscape areas, where previously it was simply a matter in SPP of saying that such areas should be given less weight than national designations. Well, now development is permissible if it has an effect on the integrity of such an area, if the benefits are more than local importance. So there's simply three examples of policy change which has altered where, if you like, the bar of acceptability sits. So I would say that the term the right development in the right place is overly simplistic, and it's helpful to some extent, but one needs to clearly look at policy direction, and evidently there has been policy change, and otherwise the government's target will simply not be met. In less than 8 years, the government wishes to double the installed capacity, and it makes it clear in underlining the word that the landscape will change. So I would say that there is clear spatial planning change with NPF4. Now, the final point I would say on that is, if you look at page 4, in terms of the spatial principles, the second last paragraph says that national developments will be a focus for delivery of the spatial strategy. And that's where the government seeks scale in development. And that is the only way in which the ambition will be attained. Going on to Mr. Ford point, that I think we're in agreement that the just transition has to apply to individual developments, and rural revitalisation is of course important. And in the onshore wind policy statement, we get a clear view from government on this at paragraph 3.3.9, where it states Scotland's onshore wind sector can bring many and considerable benefits to rural areas, ranging from the delivery of jobs and investment to the restoration and protection of natural habitats. There's no other sector that is bringing this level of investment to rural areas in Scotland. So hopefully these are some helpful just example references to where spatial planning is changing and has changed with the approval of NPF4. Thank you.
Thank you, Mr. Ball. We'll come back to national developments in a moment. Mr. Ford, I saw you with your hand up.
Thank you, sir. Yes, I'm not, just to be clear here, I'm not suggesting that there aren't changes in policy taking place through NPF4. But the point is that the right development in the right place is about assessing individual cases, weighing the merits of individual cases, and taking that policy guidance and applying it to the particular circumstances of the development. So at the end of the day, it is the right development in the right place is a case-based judgment, guided by policy accept, but it is at the end of the day a case-based judgment, individual case judgment.
Thank you, that's helpful. So I'd like to move on to the national development point, unless there was anything burning that anybody wanted to say at that point before moving on. No, okay, so in terms of national developments as outlined in NPF4, there are various references to this concept. So I think it starts on page 7 and 8 and then it carries on. There's more of an overview on page 97, and then page 103 then applies directly to the strategic renewable energy generation national development. So we can all see what it says there, but what are the practical implications of a proposal being classed as a national development? So does its elevated status, or is it an elevated status? If so, how does that alter how other policies should be applied? Or should it, for instance, affect the weight as part of an overall planning balance relative to other considerations? So Mr. Bell, you said in, I think it's 2.5.7 of your hearing statement that this means that development should be considered to be of national importance, for example. Would you like to say anything further about that now?
Thank you. Yes, I do say that, and the quote that I drew your attention to just a moment ago makes that clear in terms of the spatial strategy. I would say, as planners, this is not a new concept for us. In NPF3, there were nationally important developments that were designated specifically, and the big change is that simply a new category that's been established. Now, transmission infrastructure of 132 kV was always nationally important, but for the very first time, we've now got generating capacity brought in with a minimum threshold of 50 megawatts. So if a planning authority or a reporter was dealing with a nationally important development in NPF3, then clearly the weight to be attributed to the benefits of that development would be greater than if it was simply a major or a local application. That has to be the case. Now, clearly, that doesn't deliver a consent. There is still development management function to be done. But we now get a guide in Policy 11 and Policy 1 in terms of the weight to be attributed to development, depending on its contribution. And so you're dealing with an express direction to the decision maker on weight. It's no longer at the discretion of the decision maker. And we get clear direction that the nationally important developments will deliver the spatial strategy. So we also know that in terms of the statement of need for national development, and I referenced this for ease in my hearing statement at paragraph 2.5.4, but the government is looking for a large and rapid increase in renewable electricity generation. And the title of the national development is Strategic Renewable Electricity Generation. And we also know that the spatial strategy approach is clear that there must be significant progress by 2030. Therefore, taking all those points together in a planning determination, I would say that these all point to significant weight being attributed to the national development status of a project. Thank you.
Thank you, Mr. Bell. And for the council, do you share Mr. Bell's view, or do you have a different take on national development?
Certainly, there's some agreement there. I mean, Mr. Bell is correct. National developments are not new. They've been around for as long as we've had the hierarchy of development regulations. In the past, I suppose the slight difference that we have in the past, a classification of as a national development really only altered the determination of the application as opposed to a major development, where in the past, before the regulations changed, I think last year, they would have had to have gone to the full council in the case of national developments. But that changed with the adoption of new regulations. I suppose looking at it from the strategic point of view, yes, I can see that the national developments are significant and they're there to assist with the delivery of the spatial strategy. It is quite clear in NPF4 that they are looking to do that. Page 99, Annex B. When we're looking at the national development statements of need, that's clear in the first sentence there. So page 103 is relevant as well, and that deals with the strategic renewable generation and transmission infrastructure. As Mr. Bell pointed out, 132 kilovolt lines were national development in the past, and from a personal point of view, I have had schemes where they're interacting with substations and things to, so they would fall under the national category for that. So that was more a determination point of view, but it is clear that the generation is now part of the national mix. But for the purposes of this, we do need to look at the statement of needs as well, which I think is the only sort of change that we would point out for that one.
So on that point, then, Mr. McTeer, what is your point about the sort of difference around what the statement of needs says?
I suppose you need to look at the kind of the development as a whole, and I know that we've it was subject to EIA as well. But if we're looking at national developments, they should be accompanied by a statement of needs. We're probably not going to agree on whether the submission, is a statement of need or whether it's not. That might be a discussion for later on. But it's certainly the sort of a difference that we have up on.
I'm just scrolling through and reading at the same time as writing, and I'm not very good at multitasking, so just bear with me a moment. So, do you think that it's for individual proposals to need to kind of demonstrate a need in that context?
Yes, I do.
Well, I'll come to Stop Sanquhar 2 in a moment. Just back to the applicant on that point. Do you agree with the council on that?
No, sir, we don't. There's two fundamental points there. We don't think there's a need to demonstrate need per NPF4, and also there seemed to be a suggestion there was a difference between us in terms of the statement of need. I would just highlight page 103. There is a statement of need in NPF4. I'll just read the first bit, is additional electricity generation from renewables and electricity transmission capacity of scale is fundamental to achieving a net zero economy, and so on. In particular, it goes on, can demonstrate, can deliver benefits. So our position is that there is a clear statement of need that the government has set out that does not need to be demonstrated.
That was what I was reading when I went quiet for a moment. So I was just going back to that to the precise wording, and I suppose my question, Matteo, is that the needs case set out there, or is it something that comes in over and above that, in your view? Mr. Matteo, sorry.
Sorry, I didn't realise that was for me. No, I mean the need is there at page 103, but we're still of the view that projects have to demonstrate that they can meet that need more widely. In terms of the spatial strategy that they fit in with that. So there needs to be, certainly from our reading of it, there needs to be that detail at the project level, as well as acknowledging that there is a national need for transmission and generation of that type.
Okay, I suppose my question there would be, if it's generating electricity, does that fit the needs case? It's not saying the site is suitable necessarily, but in terms of that overarching need for renewable energy, is that something which needs to be revisited on a kind of case by case basis? Is it for the applicant to demonstrate that need, or in this case, can it be accepted that renewable energy is needed? It's just a question of, is the site, it's a large question, it's not just a question of is the site suitable, but that larger question, is that what it fundamentally comes down to? I'm sorry, Mr. McTeer, that was a question for yourself in terms of just picking up on what you said there.
I still think the case needs to be looked at, on a case by case basis. I mean, I know that the statement of need for development of that type is there, but I still think it needs to be on a case by case basis.
Okay, thank you. Okay, for Stop Sanquhar 2, please. So it's the same question around kind of the sort of role of national development. I'm interested in your view on whether or not that kind of elevates the status of, whether it changes the planning balance. And you've heard already what we've discussed there. So if you can pick up on any relevant points, that would be helpful.
Can we, before Dr. Ford speaks, can we just remind ourselves where page 103 sits in the National Planning Framework? It's in the annex headed National Development Statements of Need, and in part 3, of course, it's headed Strategic Renewable Electricity Generation and Transmission Infrastructure. So when we read at the foot of page 103 that it says what it says, it's clearly pointing in my submission to looking at individual developments and the way in which they either satisfy the perceived need in this policy statement or not, as the case may be. It's empty to talk about generalized need across the community, across the country, doesn't mean anything unless you relate it to the locational requirements of the particular development under review. I'm sorry, I'm stepping on my witness's toes and I shouldn't do that, but it seems to me that you need to remind yourself where this occurs actually in the document. Yes, I'm sorry for interrupting.
That's fine. Well, let me just highlight the points of agreement first of all, and that is, I would say, that national developments have a greater or elevated importance, obviously, in the balance of weighing the cases. But I agree with what Mr. Campbell's just said. This doesn't take away from the need to look at individual cases. In terms of the specifics of the need that you've just been discussing, I have to say, when I read the needs section that Mr. Bell read out, and he read only part of it, but it goes on, obviously, I have to say, I've found the wording unconvincing and rather confusing. Because to me, it seems to be pointing more towards the requirement for transmission than it is about electricity generation. And I spent some time looking at that because it goes on from the quote that Mr. Bell gave to talk about achieving a net zero economy and supporting improved network resilience in rural and island areas, which is quite specific. And it does seem to me that there's a bit of lack of clarity in NPF4, that there's an emphasis, for example, on transmission connections to the islands, particularly to the Western Orkneys and to the Shetlands, and because they get specific mention. But there's then generic comments about transmission improvements across Scotland. And to me, there is a kind of unresolved question here. It maybe it's not something that's just not clear in NPF4, but there's a kind of theoretical connection between renewable energy generation and transmission without really resolving the core issue here, which is that if you make generic statements, it becomes unclear really what you're approving and what you're suggesting is important. Because if you take it to the extreme, by the way Mr. Bell's reading this, it means that every wind farm anywhere within Scotland is acceptable and nationally important above the 50 megawatt. And that would imply that there's no scope for a decision or exercise of any kind of case-by-case judgment on it. And fundamentally, I would say that is not what the planning system does. We have two basic parts to the planning system. One is the development plan part, where we plan positively or seek to plan positively for development and set out policies for that. But on the other hand, we have the development management part, where we take individual case-by-case decisions. And to me, there is a gap in this. Actually, as I say, I don't think it's well worded, and I think it would be helpful if at some point the chief planner or somebody could help clarify it. Because to me, this need assessment seems to be pointing more towards transmission infrastructure than it does about actual renewable energy generation. But in terms of the specifics about renewable energy generation, it's obviously still subject to the assessment process that is set out in NPF4 that will come through later on in Policy 11, etc., etc. So I won't restate that there. But Mr. Bell has already accepted this is about contribution to addressing climate change. You're well aware, sir, from our previous hearing sessions and the submissions, that one of our core concerns about this is that this development, along with other developments, because of the energy circumstances within the country, will not make a positive contribution to addressing climate change. No doubt we'll come on to that later on. The final point to be said about this is that whilst we're talking about NPF4, we have at no point in this discussion so far recognised that this actually is an application under the Electricity Act. That is already a decision made by Scottish ministers, and it is therefore effectively, in substantive terms, already a national development. It's not a decision that's being placed with local authorities or through the usual planning system. We are already taking this decision under Section 36 of the Act as effectively a national development. So in substantive terms, my view is that actually this elevated importance of a national development fundamentally doesn't make much difference, because Scottish ministers are already taking this decision. This is not a decision being taken in the normal way as a smaller wind farm, for example, where it goes to the local planning authority and potentially to appeal process. This is already a decision being made at a national level.
But in terms of the relevance of NPF4, though, do you consider it to be a significant material consideration in a Section 36 case?
Yes, it is. But of course, I mean, Mr. Bell in the hearing session was arguing that the planning considerations are subservient to the Electricity Act.
In terms of that need point and your concerns around about what it says, is it possible to step back a bit and say this is a point of principle? It's that basic principle around support for renewable energy. It's not kind of bettering my discretion to reach whatever view I might reach ultimately based on the evidence before me. But as a starting point, there's that in principle support. Do you agree with that?
I do agree with that, but it still says, I can't remember this particular reference, but it still says that national developments still require case-by-case judgment.
Yeah. Okay. I'd like to come back to the applicant in a moment, but I'll just again double check with the airport just to make sure that there's nothing that you would like to add.
No, thank you, sir.
No problem. Okay, so can I ask the applicant to respond or reflect on what you've heard so far there, please?
Thank you, sir. Just firstly, just to correct position, I have not said that every national development is acceptable. That is simply nonsense, quite frankly. Secondly, the question that's been put is there a need to demonstrate need? And the government set out on page 103 a statement of need. So we say there is no gap in the government's position. And we just, the overall interpretation of the approach put forward by Mr. Ford, with respect, I would say, is plainly misconceived and manifestly incorrect, that it just deals with transmission infrastructure. Furthermore, such an interpretation would run entirely counter to what's in the onshore wind policy statement that sits alongside NPF4 and is very clear in its wording. So I think the last point I would say that this is one of the largest projects in Scotland in the planning system. So insofar as the government is looking for scale and to make a near-term impact and contribution, then this is the type of project that will make a material difference. Now, of course, it doesn't get over the line in terms of acceptability, in terms of national status, but it's weighing in the balance against the various development management considerations that we do for you. Thank you.
Thank you. Okay, so I think unless anybody has anything they would like to add at that point, that might be a good moment. So I want to move on to just so you know kind of what's on my list. The next thing I'd like to turn to is policy 1 and the content of that. Actually, I think because I haven't got too many questions on policy 1 itself, I think let's do that, and then we'll take a break. Once we've covered policy 1, we'll take a 15-minute break then, so we just make a bit more progress before breaking. So policy 1 is focused on tackling the climate and nature crises. So just bear with me a moment whilst I get it in front of me. Okay, so first of all, it states that significant weight will be given to both. Now, Mr. Bell, you've said that this represents a radical departure from previous approaches. It's quite strong language, so I'd just like your comments on it, please.
Thank you. Yes, I think in my experience, the matter of weight has been at the discretion of the decision maker. That's generally been the conventional approach in planning policy and in reaching determinations. But here we're getting one of the references in NPF4 where the matter of weight is set out in the policy itself for the decision maker. So there's should be no debate about that. And it's also elevating up the nature crisis alongside the climate crisis. And that is a difference compared to previous policy approaches. Thank you.
Thank you. And to the council, please, the same question. Do you see it as a radical departure from previous approaches?
It's a departure, yes. Whether it's radical or not is I suppose that's up for debate. The issue of weight and where to place significant weight's always been there in the decision making process. I suppose what we're looking at in terms of the change, where you're looking at giving significant weight to both global and nature crises, is where you look at how it sort of fits with determination more widely, and the very sort of policy connection that you look at. Policy one is all the other policies in the NPF. So you would need to look at everything in the round for that. It's not just it's not just the sort of the global climate and nature crisis. It's more a sort of an overarching ambition, I think. Certainly that's my take on it. Is that policy one is the overarching umbrella that sits over everything else. So as I say, whether it's radical or not is up for debate. But certainly it is a change, given that sort of specific nature of the wording of policy one.
Okay, thank you. And the same question to Stop Sanquhar 2, and then I'll expand it a little, please. So is it a radical departure? That's what is my question to start.
In terms of addressing climate change, I personally don't feel it is a radical departure. I would say it's an evolution of what NPF3 was saying in terms of the importance of renewable energy, and climate change was always addressed in NPF3. It was very strongly there. Perhaps I have because it's my research interest, I had a greater appreciation of it. But to me, it's the continuation of addressing climate change is not radical. I think it's important. I wouldn't in any way underestimate it. Where I do think it is radical is this introduction of the nature crisis. And that to me is entirely new in terms of policy. There's been a growing recognition in the last 2 or 3 years, really, of the nature crisis. And this NPF4 now has very substantial sections, particularly on biodiversity and ecology and things like that, in a way that we haven't really seen before in policy. And I have to say it's very welcome, because there is a great sense that we are losing biodiversity globally. We are losing biodiversity within the UK and across Europe, and we're also losing biodiversity across Scotland in particular. And I have to say that the industrialization, essentially, because that's what it is, of hilltops by wind farms has to be counterproductive to improving biodiversity. You don't have any specific questions on biodiversity, sir, but in your agenda, but it is referenced in policy 11 to point back to biodiversity. So we'll maybe pick it up then. But essentially, there is a lot of biodiversity in and around this proposed site. Golden eagles, all sorts of specialist birds and so on. But essentially, and I have to say, I have some sympathy here with the applicant. Because of this change in policy, this proposal hasn't really set out the full implications for biodiversity. I mean, I appreciate it was assessed in the normal way prior to this policy, but I think this proposal and all other proposals that are currently being reassessed in some way will be lacking in terms of the coverage of biodiversity, simply because the policy requirement to assess the implications is actually quite strong. It is not simply that, and the applicant did cover this in the application, I think there's some mention of it in Mr. Bell's hearing statement, that essentially they've gone through the process of doing within the EIA, evaluating the ecology. But actually that's not sufficient now in terms of what is required. What is required is a positive gain in terms of biodiversity from developments. It's not a matter of just of saying it's not going to have too many effects and the effects can be mitigated. It is now questioning within biodiversity terms, within policy, of actually saying each development will have to enhance biodiversity. Now, in terms of this application, that hasn't been done. As I say, I have some sympathy for the applicant because of the timing of the policy change in relation to the age of the application and so on. But essentially, my view is that this now needs to be reassessed if the decision is to consent the proposal. And essentially, the position you're putting, sir, is that you don't have the evidence to actually satisfy the current policy on biodiversity. So overall, I do think elements of policy one are radical, but they're not necessarily to do with climate change. They're actually to do with addressing the nature crisis. They were short in terms of what the applicant has given us in terms of the evidence to show that they are enhancing biodiversity. I personally don't see that as a arising from this proposal.
We can perhaps look at. I wasn't planning on looking at policy 3 right now, but we could perhaps look at policy 3 in a moment just to look at its precise wording. So that's on page 38 of NPF4. But in terms of this proposal and the evidence that we'd heard in the inquiry previously, my take was that there wasn't a particular kind of tension or conflict between this proposal and kind of biodiversity interests. Do you think is that a fair comment from your perspective? So the question I'm asking is, do we need to just kind of reconsider what policy now states in that context of there not being any specific impacts that were potentially determinative before the inquiry in terms of biodiversity?
I would agree with you that in the previous hearing, the applicant had done sufficient information to be able to make that judgment. I accept that. However, if you look at policy 3, it clearly requires an improvement in terms of the overall impact. I mean, the other thing is that policy 3B specifically mentions national and major developments and developments that require EIAs, and explicitly says they will only be supported where it can be demonstrated that the proposal will conserve, restore, and enhance biodiversity. I don't think this application in its current form meets that requirement, meets that new test that's introduced.
Thank you. So I shall revert to the applicant on that specific point around policy 3 and whether that presents any potential challenge or conflict for the proposal.
P itself refers to.
Sorry, if you can hear me now. Can I just confirm through you if Mr. Ford has read the applicant's habitat enhancement proposals?
Yes,
Can you tell me the document that he's read in that regard?
No, what I'm saying is that in terms of the previous standards, okay, it demonstrates you met the previous standard. The point is now, are you meeting the current standard that comes out in NPF4?
Sorry, I just wonder if I can ask the question through you if Mr. Ford has read the applicant's habitat enhancement proposals.
and indeed the Habitat
That's a fair
Management Plan, so specifically the HMP, because it sounds as though Mr. Ford has not read those documents.
It's a yes or no.
Well, Mr. Ford, it would help us to know, because the points you're making quite sweeping submissions, which appear to us to be misconceived. So
I have skimmed through that section. I haven't read the HMP, but I've.
So you'll see you haven't read the HMP, because in the HMP, so of course you'll see that refers to the obligation for enhancement. So we were a little bit surprised to hear Mr. Ford make the submissions that he's just made.
Okay. So we've got to be careful, not straight into cross-examination territory. I know we're not there. We're not there quite yet. But so, Mr. Ford, I think you said you hadn't seen the habitat management plan specifically. Was that correct?
I've not read it in detail in terms of a kind of thorough analysis of it. Correct. Yes, I have.
I'm not trying to trip you up with that question. It's just helpful to know. Thank you.
But the general point is that it was about. Let's be clear. There are other elements of the application, the applicant's documentation, where we have found the information provided lacking. Okay. So before I kind of accept that the evidence, well, in fact, I'm not prepared to accept that the evidence presented to the application by the applicant on biodiversity is sufficient. I would need to go through it with a fine-tooth comb to be able to say whether or not I think it meets the current standard. My overall impression is that it doesn't meet the current standard.
And presumably,
let me just clear, the odd reference to enhancing and so on is not sufficient in my view, and that is because there is a lot of work being done on biodiversity, and you'll see it coming through, through all European legislation now, and also through the planning guidance that's coming out in England, and actually still quite a lot of debate about what it means. That enhancement has to be something quite substantive and quite positive. It's not something that a little enhancement here and there will do. It's at the end of the day, a bit of enhancement to a bit of habitat around the fringes of a wind farm doesn't necessarily, for example, take into account the fact that the wind turbines themselves may have adverse effect on the ornithology and the wildlife that's around.
Mr. Campbell. You're on mute, Mr. Campbell.
Yes. Iron in the pot, sir. Could I be clear that Mr. Hardy and Mr. Bell's reference to the Habitat Management Plan is a reference to the February 2019 document, or is it a reference to a subsequent document, please?
It was updated in 2020.
So it's that document. It's that document plus the update.
Correct.
Obliged. Thank you.
And in terms of, obviously being a wind farm, when we look at policy one and we think about the sort of dual emphasis of that, it's in kind of basic terms, it's a big tick in the box in terms of the climate change agenda and working towards net zero in that overarching principle. Does that reduce potentially the extent to which biodiversity enhancement should be expected as part of a proposal which is delivering significantly potentially on the other side of that coin? Mr. Ford, what are your thoughts on that point?
Well, within the policy itself, these two things now sit with equal status. Okay.
Yes. Yeah.
I don't think there's any question about it. And that is what is radically changing. Is that I think the climate change, addressing climate change, has always been there from NPF4 and prior. But now we have this equal balancing to be measured. And we'll come on to it in terms of other policy statements later in the day. But of course, there is the issue about alternatives to be considered here. And Scotland now has a very substantial options of alternative energy coming from offshore, for example, where the impact.
Okay, sorry, I'll just interrupt you there. Sorry, Mr. Ford. Sorry to stop you mid-flow. So I don't want to focus on kind of alternatives now. What I'm interested in is that balance, regardless of what the scheme is. If it's a big tick in the box from a climate change perspective, does that, as long as there is not this kind of harm to nature and to biodiversity, is that essentially supported by policy one?
No, I don't think it is. The reason I was talking about alternatives is that, by definition, the biodiversity impact, okay, I suspect will be less offshore than it is onshore. That's really the point I was simply going to make there. But I don't think those terms of not having too big an impact on biodiversity are actually adequate within the new policy terms. I think there has to be very clear. We've heard Mr. Bell emphasise in this session and in the previous sessions all the substantive importance of climate change, addressing climate change. I am with him on much of that, okay, on most of that, in fact. But what we now have to hear from applicants is giving biodiversity exactly the same amount of weight as they do to addressing climate change. So in all of Mr. Bell's and the applicant's submissions here, we shouldn't just be hearing the importance of climate change, we should be hearing the equal amount of substance in terms of addressing biodiversity and the nature crisis. So that's not just about avoiding negative impacts, it's about creating positive benefits. Okay,
I'm going to draw us to a close in a moment. I'll just give all parties an opportunity to make any final comments on that point, if you would wish to. Mr. Bell.
Thanks, sir. Yes, just to make it clear, I did in my earlier statement make it clear that the nature crisis was elevated up alongside the climate crisis. So that's fully recognised. I think one point to add in is that clearly different developments will be able to offer different enhancement proposals. And the onshore wind policy statement annex has a number of best practice examples. Now, some of these relate to peatland restoration. So whether it's peatland or forestry, they will give rise to different opportunities. Also, in terms of the claim that offshore development is probably less harmful in terms of ecological impact, that's simply, I would say, not correct. Currently working a number of offshore developments where there are derogation cases being advanced in terms of European site impacts, and the Secretary of State has granted a number of those, certainly south of the border. So, to my understanding, there's never been a derogation case for an onshore wind farm in terms of designated site impact. So we'll perhaps come on to more of that in later policy, but thank you.
Okay, thank you. Any more concluding comments on that specific point? No. Okay, well, I think that is a good opportunity to take a break. Before we do, I mean, we're not immediately going to be talking about aviation matters. Do we know whether is Mr. Brown? I don't know whether Mr. Brown's joined us. I don't think he has yet.
Mr. Brown is in the same room as me. We just didn't want to disrupt by
Fantastic.
But he is now here.
That's great. Well, like I say, I think you still got a bit of time yet anyway, so that's great. But that's good to know. So what I would suggest we have a break for 15 minutes. So it's just coming up to 10:50. So if we could be ready to resume at 11:05, please, that would be great. You can turn your cameras off and mute your microphones whilst we're taking a break, but please don't leave the meeting just in case you can't get back in. Okay, so I'll see you shortly. Thank you.
Hello. Yeah, I'm fine. Yeah, how was that?
Okay, I make it 11:05. So if you're back at your seat, if you can just turn your camera back on, please, so I know you're there, that would be helpful. Okay, I think that's everyone, isn't it? Good. Okay, so I'd like to move on to policy 11 now, please, and that's energy. Title there, energy. So starting with part A1 of the policy, that states it supports wind farms, including repowering, extending, and so on of existing wind farms. Now, in hearing statements, there are two kind of obviously conflicting interpretations of this, and that's Mr. Bell and Mr. Ford, in terms of whether this is expressly supporting all new wind farms or whether it's actually kind of backing away from that policy approach and focusing more on repowering and extensions. So I'd like to explore that and open it up, and I'll start, if I may, with Mr. Ford. If you could outline your position first, and then I'll come to Mr. Bell, and then I'll draw in others as you wish. So, Mr. Ford, thank you.
I take it you can hear me now.
Yes, thank you.
So I do think there's an important shift taking place in the policy on energy generally. The first thing to say is that whilst we've talked about the climate change, addressing climate change remaining an important policy here, there is a general shift in terms of how climate change is addressed, such that it isn't purely about generating energy from low carbon energy sources. It's also about decarbonising the wider society. And my assessment is that this comes from the fact that effectively the electricity system in Scotland is decarbonised as much as it can be at the present time with the current technology. And the only way we will move towards fully decarbonising electricity generation in Scotland is if we take out primarily Peterhead Power Station and convert it to carbon capture and storage or something like that. So that's the context for this policy, is that effectively the electricity system within Scotland is already decarbonised. And in our submissions from 18 months or so ago, we set up some numbers there about the level of generation within Scotland, how much energy was being used in Scotland and how much was being is excess well above that. And even by the current capacity, there is considerable excess of renewable energy within Scotland. The problem with decarbonising the electricity system in Scotland is simply that we need to find other ways to deliver renewable energy when the wind isn't blowing. And obviously this proposal doesn't help that problem at all, because it will blow essentially the wind farm fleet across Scotland act together. They all respond when the wind's blowing, and they all tend to be not producing when the wind is not blowing. So there is a general shift in Policy 11 to recognise that different technologies are going to come in and are important. So that's the first thing to say about it. And as a result of that, wind farms, particularly onshore wind farms, are one of 5 or 6 different renewable energy sources that will be available in the future. Then we come to the specifics around onshore wind farms themselves, and it's very clear that in the wording of NPF4 A1, as you pointed out, sir, the wording has importantly shifted. And we don't see any particular reference to wind farm proposals on new virgin sites. We see reference to repowering, extending and expanding existing sites, essentially where the use of a site has been proven to be acceptable because there's a consent there. So expansion of that. And we gave evidence in the earlier hearing session about the fact that repowering can actually increase the amount of energy coming off a wind farm proposal by as much as 4 or 5 times. We'll come on to that figure a bit, no doubt, later on in the day. But within 11A1, there is no explicit reference to wind farm proposals on new virgin sites. Now, I'm not saying that they're specifically excluded by policy. What I am saying is that the policy emphasis has shifted towards repowering, extending and expanding on existing sites. So I'm not saying there's a moratorium or some kind of way of preventing this proposal being granted if that's the balanced judgment at the end of the day. But the policy emphasis is clearly towards repowering of existing sites. It's very explicit. And we'll come on to discuss what those can deliver in terms of capacity when we discuss the onshore wind policy statement later on in the day. But essentially, as I say, there isn't an explicit exclusion of new virgin sites, but there isn't policy explicit support for it either. Thank you, sir.
Thank you. And then for the applicant, please. You've just heard what Mr. Ford's outlined, so I'd like your view on it, and also on your view on what Mr. Ford said.
Yes, we consider Mr. Ford is wrong on this interpretation of Policy 11. The suggestion that Policy 11 does not apply or places much less emphasis on new virgin sites or greenfield sites, we say is manifestly incorrect. Policy 11, if on a proper reading, provides support for development proposals for all forms of renewable, low carbon and zero emission technologies, including wind farms. It says wind farms, including repowering, extending, expanding, and extending the life of wind farms. So the word including quite clearly includes extensions, repowering, within the scope of wind farms, which on a plain reading means new wind farm development. I would say there is no wording in Policy 11 that could be sensibly interpreted as suggesting that it does not apply to new wind farm development or places much less emphasis on that. Furthermore, as I've said before this morning, such an interpretation would run entirely counter to the statement of need in relation to strategic renewable electricity generation and transmission infrastructure, and indeed to a number of the statements set out in the onshore wind policy statement. Thank you.
Thank you. I said there was a difference of opinion, so I think I've categorised that correctly. In terms of the council's view on that, yeah, what's your view? I don't need to make it more complex than that. I'd like to hear your view on it, please.
Or are you asking us to pick a side? I think certainly on our reading of it, I would agree with Mr. Bell. From my reading of Policy 11, all forms of renewable technology, so it's not excluding anything. In fact, there's 7 different criteria that kind of outlines all the types of renewable energy that's there. Perhaps point 1 would have benefited from the comma that's point 2 and 3 have got. So it could be wind farms, including repowering, extending, expanding, the life of existing wind farms. I mean, the only thing that I'll sort of point out from that part as a case officer for this type of development, I have these things looming on the horizon for repowering and things, and it just kind of I suppose in policy terms it's kind of the first time that we've seen the explicit mention of these types of developments, but I'm not looking at it in any different way. So, thank you.
Okay, I don't have any more questions on that particular point, so I'm happy to move on and consider what you've all outlined there. So thank you. Okay, so I want to look at policy 11C, part C of the policy now, please. So this states that proposals will only be supported where they maximise net economic impact. Now that's quite strong wording for policy, in that unless the economic impact is maximised, the proposal will not be supported as outlined in that criterion. So even if very substantial economic benefits are on offer, I suppose it still begs the question of whether these could be greater before being maximised. It's a slightly tricky one. So my question is kind of how should this be measured or assessed? So how can one establish whether the net economic impact has been maximised in this context? Mr. Bell, shall I come to you first, please?
Thank you. I would say that this is perhaps more of a re-emphasis than a new policy matter. The government's always taken the view that it wants to maximise the benefits from renewable energy development and onshore wind. And the development in this case would deliver a range of benefits. They were set out in the original hearing statement that I prepared in summary. And that referenced the things like the capital investment of 337 million, 200 jobs during construction. But importantly, there were two other points. One is that the overall investment, if you take into account the operational period, was referenced at some £1.14 billion of investment. And the applicant also provided a commitment to communities report, which was CD 001.004, which sets out a buy Scottish policy. And there are not many developers that have a policy approach like that, that is explicit at the application stage. And that is one principle that applies to the key elements of the development. So in terms of track record, for example, the vast majority of civil engineering contractors that the applicant has engaged on its past projects have been Scottish. But there's clearly a limit now in terms of what can be done in terms of wider supply chain, in terms of tower manufacture, which previously was at Machrihanish in Argyll, but unfortunately no longer is there, and the turbines themselves, which have to come from overseas. So in terms of what the applicant can do to maximise the local content, the Scottish content, it does that. It has an established policy. And I think there needs to be also recognition that in the onshore wind policy statement, the government has set out that it's committed to a sector deal for onshore wind in the same way that it has done for offshore renewables. And that model is all about ensuring that the Scottish wider supply chain can benefit. And that's being done in offshore wind. And the intention is that that will be rolled out for onshore wind. And that will, in due course, set out the way in which the development at scale, the deployment at scale can further develop. And that links to the just transition and what we were talking about at the start in terms of jobs and skills, and hopefully that manufacturing capability for steel, towers, and so on, which can start to more substantively increase the Scottish content of that substantial investment to reach the government's ambition of 20 gigawatts. So my position would be, we don't have any guidance to go along with this policy 11 yet. That may come, but the applicant has set out the substantial impacts that would be positive, that would come from the scale of development, and it has some added aspects to its procurement approach that mean that it can be said with some confidence that the developer is doing what it can to maximise the economic benefit that the project would have. Thank you.
Thank you, Mr. Bell. And then Mr. Ford, so in 2.3 of your hearing statement, you said it cannot be said to have been maximised, talking about the net economic impact. Could you say a little more about why you take that position, please?
Okay. The context for this is that there's been a lot of pressure and pushing on the UK government level and on the Scottish government level in the last 4 or 5 years, arising out of concern with the exceptionally poor supply chain benefits that come to the local economies, that's UK and Scottish economies, from wind power developments. The industry loves to make some wonderful claims and warm words about its support for, say, Scottish industry and Scottish economic activity and so on. But the reality is that the track record over the last 10 years has actually been exceptionally poor. And that's the reason why it's becoming effectively a requirement now that wind power developments are required to make a much more substantial and substantive economic contribution to the local area in which they are and into the country generally. Now, developments which are going to go forward for subsidy through the contract for difference scheme will have a formal requirement burden put on them that's already being introduced from the last auction round for offshore and is also being introduced much more substantially for the coming auction round for CFDs. So there's a clear requirement to increase a percentage, to provide a percentage benefit for the country, okay? And I'm not aware of what the figures are, but we were thinking of something of the order of 40 to 50% in terms of the minimum that is required. So that's the cost that's spent by the developer in terms of building the wind farm. So Mr. Bell gave his figures there of the overall investment cost. The expectation coming from certainly UK government through the CFD mechanisms is that a minimum percentage of that will be required to be locally sourced and making a contribution to the UK economy. At the Scottish level, Scottish government has less direct policy levers, if you like, on this because obviously they don't have something similar to the CFD mechanism. But they've also embraced this sense that the supply chain record has been frankly atrocious over the last few years from the wind industry, wind development industry. And whilst Mr. Bell gives the usual warm words that have been given by the industry and still to be given by the industry, they don't really reflect the new requirement that's now in place for substantial benefits in terms of supply chain opportunities. The second thing is that this is not just a Scottish and UK-wide issue in terms of supply chain. Policy 11C is actually introducing a new requirement and a much greater emphasis than existed previously. And I certainly accept Mr. Bell's point that net economic impact was a consideration under previous policy. But as you've quite rightly recognised, there's now a much more explicit requirement for it, and it's about maximising the net economic benefit rather than just measuring what that might be. So the other part to this is not just the supply chain, but also the impact on the local economy. And that's very explicit within the policy. So it's local and community social and economic benefits. So they give examples of employment and business activity, but it also goes to things like community benefit and the consequences that arise for the community. Obviously, taking households out of the local economy in the way that this applicant has done for this proposal is counterproductive to that. But the other thing is that whilst they've pointed out that they've increased the community benefit scheme from a derisory figure to the general requirement that's in Scottish policy guidance, and that's to be welcomed. The problem with the community benefit scheme is that they are, well, there's a few problems with them, basically. One is that this £5,000 threshold was set something like 10 years ago at the stage when the output from electricity was from wind farms was quite modest. And it was always set in terms of the capacity, the copper plate capacity of the wind farm as a multiple of the megawatt capacity. At that time, the output from wind farms was traditionally between 20 and 25% of the potential in terms of a load factor. The applicant for this proposal is actually suggesting that the load factor will be 45%, and therefore the output in terms of electricity against the plate capacity is substantially higher. And on that basis, realistically, to be equivalent to the old terms, the community benefit should be something between £8,000 and £10,000 per megawatt plate capacity. So that's one issue with it. The second issue is that community benefits are actually not monitored and not tracked, and therefore there is no way of verifying that the commitments that are given, and wind farm developers always give very strong commitments at the point of application when the map is up for determination. But there's actually no monitoring process going on behind that to see whether those promises are being fulfilled. As a matter of fact, this applicant actually has a poor record of fulfilling those benefits. At their Aikengill wind farm development over in the East Coast, I gather they are 50k behind their current value in terms of what they should have paid in community benefits.
Okay, so I don't want to get into the detail of other cases and
sure,
kind of that side of things. So I'll just stop you there, Mr. Ford, for a moment. So in terms of the supply chain point, that's a point that's been made strongly by both sides in terms of the importance of that, and that's a kind of a key aspect of considering whether net economic benefit has been maximised. Now, Mr. Bell directed us to their commitment to communities document, CD 1.4, and the sort of Buy Scottish principle embedded there. Does that help, Mr. Ford, in terms of your concerns around whether or not the supply chain is benefiting Scotland on kind of local areas more directly?
Essentially, it's appropriate to the old pre-NPF4 arrangements. So in other words, it's part of that poor track record that the industry have had in terms of not really delivering supply chain benefits, and in terms of the standards that are being set, and these requirements are still evolving at both the Scottish and UK government level. Okay, but I suspect at some point we will see a finite requirement in terms of minimum commitment for spend within the country coming from Scottish government. It's evolving and formulating at UK government level, but essentially those commitments are just at this moment in time warm words, and they have no substantive meaning. I appreciate the intent, but the practice and the track record over the last few years has shown that it's not acceptable, and that's the reason why there's a whole emphasis in terms of supply chain being developed by the UK and Scottish government levels. So essentially, my view is that this proposal, in its current form, with the current benefits offered, do not comply with the new standard that's been set in policy 11C.
Okay, thank you. In terms of, and this isn't just to you, Mr. Ford, in terms of the community benefit payments, Mr. Bell, towards the beginning of the hearing session, you mentioned that you'd increase the rate to £5,000 per megawatt, and there was the establishment of an energy fund as well, and I noted down the purposes of that. Is that now a material consideration potentially in terms of what NPF4? Sorry, just in terms of what NPF4 now says in Part C that we're looking at now. Obviously, historically, it's certainly not been a material consideration. So sorry, yeah. Mr. Ford, you can go first, and I'll come to Mr. Bell. Thank you.
Yes, historically, it's not been. It's been ruled out because of the essentially a planning principle that we don't consider those benefits within planning decisions, and that's to do with a long history of betterment and those kind of issues, really, which goes back to the 47 Act and all sorts of history around that kind of thing. So, and there's also been legal judgments about it in terms of excluding that as a material consideration. However, my sense is that this policy here is now introducing that as a material consideration. My hunch is that this will be subject to legal action at some point over the coming time, because it does run counter to the long-standing principle, but it does seem to mean that we should now be considering community benefits as a material consideration. What weight it's given is obviously a separate matter, but my view is that effectively from this point onwards, we should be considering it as a material consideration. I do feel it's likely to be challenged by, if a decision was entirely based on, which is very unlikely, obviously, was purely based on, if everything else in this proposal, for example, was acceptable, and the only thing that was unacceptable was community benefit, and the application was refused on that basis, I'm sure it'd be subject to challenge in the courts. But essentially, that's my reading of this policy now, is that community benefit, and this is not just in terms of what we call community benefit in terms of the good practice guidance of it, but it's also in terms of wider benefits beyond that as well. But yes, my reading is that this is now a requirement.
And Mr. Bell, and I'd like the council's view on this as well in a moment. But Mr. Bell, please.
Sure, I would caution against that. My view, based on legal advice I've received consistently, is that would be unlawful to treat financial payments such as specific community benefit payments as a material consideration. So my position is that is not what the policy is saying, and that there's been no change, that's my understanding, to that position. In this case, the £5,000 per megawatt would equate to around £1.5 million per annum. That's a substantial sum, but I would say not material for decision making. But insofar as the policy references local, community and socioeconomic benefits, such as employment and business and supply chain opportunities, these are material. And the Buy Scottish policy, in terms of the elements of the contract that logically should be local, and there would be many contractors who can provide services in that regard. These are material matters, and the Buy Scottish policy would fit with that. I think, going back to one or two of Mr. Ford's points, in terms of the Scottish manufacturing capacity for towers and turbines, that's quite a big element of content for developments. But he seems to be suggesting that you cannot build developments until there is some form of Scottish manufacturing capacity. That is not the government's approach. And if we look at the onshore wind policy statement, paragraph 5.2.3, in terms of supply chain, it states, over the coming years, we have a real opportunity to create an established manufacturing industry based on circular economy principles. And it goes on in the next paragraph to say, Renewable UK is currently working to fully understand the supply chain opportunities for Scotland. We expect their report shortly and will use it to inform our approach to maximising supply chain benefits. So I think clearly the government is intending to ramp up deployment further and faster, as it puts it, and that in itself will contribute to greater potential for supply chain to be provided locally, because clearly the greater demand, then the greater the confidence that suppliers could have to locate, whether that's Machrihanish or in another manufacturing facility, whether that's DL or elsewhere. Thank you.
Thank you. In terms of whether or not I can take any account of the community benefit payment, I can't recall seeing anything from the applicant in terms of confirming that increased figure. So whether or not I can take it into account is a separate point. Have I received that? And it's just something I can't recall at this, given the time that's passed.
I think, sir, as a result of what's happened, a statement can be submitted if you'd be willing to accept that. Just confirming what Mr. Bell has said this morning.
I think that would be helpful if it hasn't already been submitted. If it has been, please just direct me to it.
No, it hasn't. It's a decision which has been made in light of the changes. So we'll do that this week.
Thank you. And if that could be circulated to all parties, obviously that would be appreciated. Thanks.
Yes, of course. Yeah.
Okay. So I said I'd like to just get the council's views on the point around materiality of community benefit payments, but I'd also welcome you to just kind of comment on anything else that you've heard on this part of the policy, if you'd like to.
Sorry, if I could start off and then pass over to Mr. McTeer. On the community benefit point, I mean, what can be a material consideration is a question of law. Policy documents cannot make something that is immaterial material, just as they cannot make something the other way around. So as far as this policy document is concerned, NPF4, the draft, it cannot and does not change the law. So the law, as I think Mr. Bell has accepted this, there's no change in the law as far as the materiality of community benefits is concerned. On that sort of legal point, I'll pass over to Mr. McTeer for other comments.
Thank you.
Yes, we don't have a great deal to go beyond what's already been discussed so far. The socioeconomic benefits have always been there. They are part of our development management considerations under LDP2 policy IN2. I think the only thing that really changes is the policy hurdle here, where it does say that proposals will only be supported where they maximise net economic impact, whereas previously they were just one of the considerations that were in the overall mix.
Okay, thank you. Mr. Ford.
Can I just pick up on this point about the legality of the community benefits payments and materiality and so on? I certainly recognise that historically, legally, they've been excluded. So let's be clear about this. But I think it's useful to provide some context for this, and that is that the situation is changing. It's been particularly driven by policy and shifts in guidance that's coming from the UK level, okay? And in England in particular, they are looking at not just a closer involvement in terms of the local community, in terms of giving support and consent to wind farms, or not, as the case may be, but they're also looking at stronger terms of reward and benefits for the community from wind farm developments in their immediate locality. So it does look like there might be some shift in the law in terms of, assuming this is followed through to practice, in terms of what can be considered, because they are talking, for example, about not just giving benefits, financial benefits to a community as a body, but they're also talking about giving direct economic benefits to residents individually. So they're talking about subsidising electricity, or even giving free electricity, for example, but also other direct benefits associated with addressing climate change, like paying for insulation for housing and those kind of improvements that would reduce the carbon emissions, if you like, of individual dwellings. So it is, whilst I accept what Mr. Armstrong and Mr. Bell say about the legality historically, I do think we're in a changing picture here, and we may well see some change in the next year or two. I did preface my remarks by saying I thought this might well go to court for testing in the next year or two.
Okay, thank you. No, yeah, that's noted. Right, lovely. Okay, so I'm going to move us on. I want to look at Part E of the policy. So, okay, yeah. So now I don't want to go through each of the individual potential impacts it lists. We'll look at a few of them in detail where I've got questions. But I'm interested in your thoughts on what it means to where it says demonstrate how the impacts are addressed. What does addressed mean? presumably it can't mean completely resolved or avoided, because I think you would be struggling to progress with anything. So, and I suppose part E2, where it talks about landscape and visual effects, wouldn't make a great deal of sense in that it's accepting of significant landscape and visual effects. So I'd like views on what that choice of wording kind of means in practice in terms of applying part E of the policy. So I'll perhaps start with given it's a policy point. I'll come to the council first, and then the applicant, and then Mr. Ford, please. So we'll start with the council first. Just as and when you're ready, just take a moment to read it if that's helpful.
Thank you. Yeah, I suppose looking at it from our point of view, you're never going to be able to mitigate everything to the nth degree. So you have to accept that there will be, some things that won't be fully mitigated against to the satisfaction of everybody. That's just not going to be possible. Whether there's any guidance comes through on these points in the coming months or years, we have to wait and see. I suppose the points that are listed under E, you need to kind of cross-refer them to the key policy connections that are associated with them. So that would give some indication on the more specific issues that sort of face each of the criteria. So looking at point 9, it goes on to buy. There's a key policy connection there back to policy 3, where and we touched on this earlier on. It's obviously it's something that's come out of policy 1. Everything coming back to policy 1 about tackling the climate and nature crisis in parallel. So looking, for instance, like I say, policy 3, for developments in this case national and also that require EIA. Would be supported where it can be demonstrated that the proposal will conserve, restore, and enhance biodiversity. So that goes some way to addressing that particular sort of criteria at 9. Part E, part 9. So from that point of view, certainly in terms of the biodiversity there's a shift in policy there. In the past, you'd be looking for no negative impacts on biodiversity, whereas now we're looking for a positive sort of change on biodiversity. So it's a slightly different hurdle to look at. Point 2, I know you drew us to point 2 with landscape and visual impacts. Again, there's a key policy connection there to policy 4, which is natural places, and it's something that has been covered both in my colleague Andrew's statement, which was at paragraph 6.2.5. To do with the regional scenic areas. So looking at policy 4, part A and part D, where we're looking at local designations, and point 1 of D, development won't have a significant adverse effect on the integrity of the area or the qualities for which it's been identified. So Andrew concluded in so far as the regional scenic area goes, that it was our view that the proposal, by virtue of its design and scale and lateral extent, would adversely affect the integrity of the northwestern part of the Thornhill Uplands RSA and the qualities designated. So that's a bit of sort of detail to do with this specific.
Just to interrupt you there, Mr. McTeer. Yeah. Sorry to interrupt. We'll hold that thought on policy 4 anyway, because I want to come back to that under item 3, where we look at the consistency between the LDP and NPF4, because I think that's where that should be drawn out. But in terms of your take on kind of the word address there, it's not a case of everything has to be resolved. It's a case of working through and making reference to all the relevant policies and seeing and testing that compliance accordingly. Is that a correct summary?
Yes. I mean, it's the key policy connections for us. Kind of highlight how you would go about addressing things in the wider sense. Again, I go back to the first point that I made in that it's not going to be possible to mitigate everything to everybody's satisfaction to the nth degree. So it's certainly it gives us a steer, each of the sort of the individual policies that you sort of revert back to, and it's a theme of NPF4 more widely, in that you need to read it as a whole. That's Annex A, I think it is. But I'll maybe that just now.
No, that's helpful, thank you.
Okay.
And over to the applicant, please, whether it's Mr. Hardy or Mr. Bell.
Thanks, sir. I think it's a very simple, short answer I've got to your question. In terms of impacts being addressed, it would be such that they are satisfactory in land use planning terms, using planning judgment. Now, Mr. McTeer said, we're waiting some guidance. We do actually have some guidance on the key topic in this case, in terms of landscape and visual amenity. Section 3.6 in the onshore wind policy statement is about the NPF4 policy in the title of section 3.6. And it tells us there that because of the rapid transformation needed and the need for taller, more efficient turbines, this is paragraph 3.6.1, this will change the landscape, underlined. It goes on to say that LDPs should realise their area's full potential, and goes on at 3.6.2 to reference stronger weight is being afforded to the contribution of the development to the climate emergency, as well as community benefits. So there's clear direction. In fact, we get more guidance in the onshore wind policy statement than we do in NPF4 on this topic. And there's reference also to where impacts are localised and or appropriate design mitigation has been applied. So at the end of the day, it's about ensuring that the impacts are satisfactory, not that there's no adverse impacts, because we know that that change is clearly being anticipated and signalled in the policy itself. Thank you.
Thank you. I'm just wondering whether the end of Part E helps us out here as well in terms of understanding what addressed means, where it says in considering these impacts. So that's a different word immediately. In considering these impacts, and then we give significant weight, but then it draws on the planning balance to weigh all the considerations up. Mr. Ford, have you got anything you'd like to add to that discussion?
Yes, sir. Mr. Bell's kind of talked about the result, if you like, but I think addressed actually is more of about a process. So in using the word addressed, I think they're saying more than just having regard to, in other words, just, recognising it's there. I think they're actually saying that the effects need to be identified, they need to be fully understood, and where they're adverse, because there will be some adverse effects and some non-adverse effects, they need to be mitigated and taken forward and identified and in some way dealt with. So the satisfaction that Mr. Bell talks about in the general planning balance, I think need to be part of a process that, if you like, shows how they are made minimum, mitigated, reduced, avoided, so that you get to the minimum consequence of a development, and then that is to be judged against the positive contribution against of addressing climate change. So, I mean, obviously, if you can't address climate change, then all the negative benefits still stand on the table. But I think we have to assume that addressed means some formal process. Now, that may have been carried out for this application in respect to the EIA, but you know, I do think it means more than just saying it's satisfied and it's a kind of woolly thing. I do think there's a formal process to be carried out here to be satisfied that these issues have been addressed. And in the meantime, sir, I've lost you from the screen, so I assume you're still there.
I am still there. Has anybody else lost me from the screen?
That's fine.
I don't know. I can see everybody, and I've got perfect sound quality at the moment. So I hope to reappear soon.
Thank you.
Okay, thank you. So I don't think I need to ask any more about that particular point. So I'll move this on. So I'm mindful that in the first hearing, the first policy hearing we had, we discussed grid capacity, and I don't want to go over the same ground again on that point, but I do just want to ask about what you said, Mr. Ford, in 2.6 of your hearing statement. So you said there, as Stop Sanquhar 2 pointed out, NPF4 states this is limited to connections to the grid. When I've gone back to policy 11E, I don't read it in the same way. So as I'm reading that, I read it as grid capacity and connections being two separate matters. But I'd like you to explain otherwise, so I understand it correctly if I'm not understanding it correctly.
Okay. Well, obviously, SPP did have a reference to grid capacity. You know, the section we discussed in the previous hearing about, I think, SPP 169. Yeah. And this reference to grid capacity was not dealt with in the draft NPF4. Okay, it was omitted. So I do wonder whether Mr. Bell's had some influence in the background, and the industry's had some influence in the background to try and resurrect it and reinstate it, if you like. But
I'm sure you've all had some kind of input in some way.
Indeed, and there's nothing to say that that's not legitimate or anything like that. The policy Absolutely is what it is. No. But I still, my feeling is still that the wording is really reflective of the old SPP 169 policy. And whilst it talks about grid capacity, I said under the previous session that really it would be better worded as grid access, because the fundamentals are that any developer, any wind farm developer, any generator, for example, has a right to gain grid access anywhere in the country for the capacity that they require.
But that's the connection point, isn't it? So that's the
that's the point between the wind farm and the nearest substation, essentially.
But grid capacity, as I read that, I think, well, have the transmission lines got sufficient bandwidth? I'm sure that's not the correct term.
That's a good enough term.
To take on the energy inputted by a new scheme, and it's saying there grid capacity should not constrain renewable energy development, and that's why I'm slightly struggling there with in terms of what you said.
No, I understand that, but it goes on to say it is for developers to agree their connections with the grid. So I think that's again, as I said in the previous sessions, I think it's an unfortunate wording. I think what they mean is grid access fundamentally. My suspicion is, and I wish them well with this, that the planners that drafted this don't really understand the nuances of what's going on here. And you know, that's a reflection of the fact that the electricity regulation system and electricity policy sits outside and away from the Scottish Government Planning Unit. But I do think this grid capacity phrase is qualified by the subsequent section, the subsequent sentence, and which says it's for developers to agree connections to the grid. Okay, so I do think it's still talking about specifically the first connection to the grid. So in my view, the wider issues about what's happening with overall capacity and the ability to export, for example, are still pertinent and material issues that have to be considered.
Okay. So I'd like to give the applicant and the council an opportunity to comment on that if you wish to. Mr. Bell.
So yes, just say we disagree with all of what Mr. Ford has said, and we will just stick with the written submissions we've already made on this topic. Thank you.
Thank you. And for the council, do you wish to add anything?
No, sir. This is a rabbit hole we're not going down. Okay.
Okay, no, that's fine. Well, no, it's helpful to clarify because I wanted to just get under the skin of that, Mr. Ford. So thank you for your for explaining that. Okay, and then sorry, this is real nitpicking, so I apologise in advance. I don't normally do this, but I just want to check. I think there might be a typo in your hearing statement, Mr. Ford. So it's the 6th line of 2.6.
Where you say, I just get my statement back up?
Yeah, of course you can. Yeah. So paragraph 2.6. Yeah, so it's the 6th line down on 2.6 where you say does not necessitate. Do you mean not?
Yes, it does.
Yes, I do, sir.
Yes, it does.
Yeah, I do. What I'm saying is that
I'm not okay. Yeah, so I need you to explain that then, because I don't understand quite what you're saying.
If I may try and help, sir, the logic of this is that if the not was not there, then any applicant for a wind farm would have to be cognizant of the wider grid capacity structure. And that would be ridiculous, because if you're building a wind farm, as is proposed here, over several localities, you've got to be cognizant of the capacity north, south, east and west. Mr. Hardy's laughing, Mr. Bell's laughing, but it's absolutely nonsensical to suggest that any wind farm developer should be cognizant of all of those issues, which are unique to the transmission industry and nothing to do with the location specific requirements of the particular development.
the other thing about that sentence, sir, is it's also addressing this issue. It's about the local connection as opposed to the broader picture.
Okay, that's helpful clarification, because I'm reading it back to myself and I still don't quite read it in the way that you've explained, but I've understood the point that you're making, so I'm very glad I asked you. So I don't think I need to pursue that any further, but thank you for the clarification, both of you, on that. That's going to haunt me. I'm going to keep reading it back now and see what I make of it.
Well, I'll read it back. I'll take some time at lunchtime just to go over it again and check it. So
no, it's fine. Yeah, I'm sure it's me and not you. So no, that's fine. Thank you.
No, I'm not sure that's true.
Okay,
it is quite a subtle point. I understand that.
Yeah, no. I think
the reason why it's expressed like this is fundamentally that the test that's set out in NPF4 at the end of E is this test about the contribution of proposals to renewable energy generation targets and greenhouse gas reduction. Okay. The point is that fundamentally, if you can't use the electricity, you can't make a contribution.
Yeah, no, I understand the point. I understand the point completely. Okay, thank you for that. Okay, so just moving us on. Now, I've noted which other policies have been referred to in statements, and we'll need to refer to policy 4, as I mentioned, under agenda item 3. But to avoid duplication, I don't intend to ask about that policy right now. So is anyone eager to raise anything about other relevant policies NPF4? Because if not, I'm happy to rely on submissions at this point in terms of other policies.
Nothing from the applicant, sir.
Okay, I'll just check before I come to you, Mr. Ford. Council, have you got anything you'd like to raise in terms of other policies?
Well, the fact that we're going on to policy 4, we're obviously wanting to raise issues in relation to policy 4, but nothing else. I mean, we've already discussed policy 3 and obviously the change in the policy position there, as opposed to the previous government policy positions.
Okay, thank you. Mr. Ford, I saw your hand.
Thank you very much. It is it is stated in the submissions, but I just want to reiterate the point that there is this general shift in terms of the position of renewable energy and wind farms in general. But also, I think it's an important point that the primary requirement to address climate change from Scotland now is not about decarbonising electricity. It's about decarbonising the rest of society. And that's a very important imperative. That, to me, is what NPF4 is essentially addressing in terms of this very fundamental shift. That it's not about building more wind farms to reduce carbon coming out of electricity generation. The requirement now, because we've essentially satisfied almost as much as we can do, the decarbonisation of electricity generation in Scotland, the requirement now is to decarbonise the rest of society. So it's about taking carbon out of heating for homes, out of industry and out of transport and those other areas.
Okay. I would say, thank you. I would say hold that thought as well, because in item 5, I'll allow you all to kind of pull everything together in that way. So I understand the kind of the emphasis that I should be taking from our discussion. So on that note, unless anybody else has anything they wish to raise, I intend to move us on to item 3, and I want to look at the LDP policies and their consistency or otherwise, as the case may be, with NPF4. So this section is probably going to mainly involve the council and the applicant, but you're all welcome to contribute where relevant, of course. But turning to the council first on that note, and just a point of clarity, really. So in 2.3 of your hearing statement, you've said that one has to determine as to whether NPF4 is consistent with the terms of the development plan and vice versa. Now, I might be reading too much into that and what you've said, but does it work both ways? So does it matter whether NPF4 is consistent with the LDP, is my question, or is the onus on the development plan to be consistent with NPF4?
So perhaps just starting on the legal point in relation to that section 13 of the 2019 Act, which my understanding will come into effect at the same time as the NPF is published, amends section 24 of the 1997 Act and sets out that in the event of any incompatibility between a provision of the National Planning Framework, provision of a local development plan, whichever of them is the later in date is to prevail. So the legal test in terms of if there is a difference between the policies in the NPF and the LDPs is incompatibility. That is quite a high test. It's contrary to, rather than, I suppose, inconsistent means it does not match or it's not directly the same as. But the legal test is incompatibility. And obviously, in this case, on dates, the NPF comes after the LDP's adoption. So the question is whether there's any incompatibility rather than inconsistency. If I then hand over to Mr. McTeer.
There might not be much to add, Mr. McTeer, but that was a clear answer. But feel free.
No, not much more to add on that particular sort of point. And I think the hearing statement that I've put in, I've tried to include where we think the most relevant LDP2 policies are consistent with those in NPF4, and just where we're kind of looking at areas of similarity. I probably don't need to go over them all. We've looked at policy IN1 and IN2 in terms of tackling the climate crisis, if you will. I touched on policy 4 earlier on. in terms of the sort of the designation or the qualities of designation of the regional scenic area. It was covered, as I said, by my my late colleague. He's not dead, but he's just moved on. He covered that in his statement, and also if I could just withdraw into to the council's landscape architect's response from page 103, which I think was CD 5.5. So we were looking at the regional scenic areas in terms of impacts on the designation of that, and my colleague does note that there would be a sea change in the sort of the characteristic of the area of the regional scenic area. So I'm not going to dwell any further on that. Though I did mention a couple of other policies within the statement which were relevant but didn't really materially affect our position on the case. Things like minerals and tourism. I don't think we need to go over those
no,
either.
So I've got some questions to follow in terms of where I think the kind of key policy issues are. We'll come on to. So, but just before we do that, I'll come back to you in a moment, Mr. McTeer, but I'll just check with the applicant. Were you content with what Mr. Armstrong outlined there in terms of the kind of legal status and how that compatibility and consistency point should be addressed?
Yes. And do you want any comments, yes, or on policy 4?
No. Thank you. No, we'll come on to it. Very shortly, but just hang fire for now. Thank you. So before we look into kind of the detailed kind of policies and what NPF4 policy 4 states. So we've already touched on the emphasis of NPF4 and the focus on a just transition to net zero and the significant weight given to the global climate and nature crises. My question is for the council first, is that a different emphasis to the LDP in overall terms?
I think in overall terms, I mean, obviously the LDP is a product of its time, but it's still up to date, still within its time frame. Certainly, the sort of key paragraphs that I referred to in my statement, just in so far as we're looking at tackling the sort of the climate crisis, is there. I don't really have much further to add to what's already there. I think they are obviously, that these are two documents that are sort of several years apart. So it could be, and there's obviously part of NPF4 is identifying what development plans will include. So we're kind of at that sort of funny in between stage just now, where there are transitional sort of differences between sort of policy areas, and that given the sort of the space of time, they'll probably align in a much closer way, rather than just at the sort of the kind of higher level sort of level, if you understand what.
Yeah. Okay, thanks. Yeah, so the same kind of point to the applicant. I mean, it's not something we need to necessarily dwell on in any detail. It's just that I'd like your impression of the overall kind of sense of the LDP and how it sits alongside NPF4, and whether it sits comfortably or not.
Yes, in answering that, so I think we need to remember this is not a town and country planning application. Sure. Section 25 does not apply. The development plan remains a material consideration. But the LDP was adopted in 2019, and it clearly went through an examination process, so it would have been formulated well before that. My understanding is it makes no mention whatsoever of net zero. It also contains a spatial framework for wind energy, which is inconsistent with NPF4 in its broad policy approach. That's in particular through its supplementary guidance. And there are some very specific inconsistencies of some policies that we'll come on to. Therefore, we fundamentally disagree with the proposition that the LDP of 2019 is in lockstep with NPF4. We say that that simply is not borne out by the facts when the policy wording is examined. Thank you.
Thank you. Well, I'd like to start looking at policy wording now. So, in terms of policy IN2, is where I think that's the starting point. Really, we in the previous hearing there was agreement that that was the principal LDP policy relating to wind energy. And I'd like your views on kind of, I suppose, the policy emphasis of policy IN2 and also the policy requirements of IN2 in the context of NPF4. So a very specific example. We look at policy 11 in NPF4 E2. That provides the kind of qualified acceptance of significant landscape and visual effects. It's that particular point that I'm looking at. So, as a worked example, does IN2 have that same? Obviously, it's not quite the same. It's not quite the same requirement. But in terms of that emphasis, I'm interested in just exploring whether or not there are kind of any sort of fundamental or significant differences. And of course, noting Mr. Bell's point around it's not a Section 25 test to apply in this case. But that notwithstanding, I'm interested in kind of where policy IN2 takes us and whether it's a higher bar or a different kind of emphasis to that's coming through NPF4. I should perhaps start with the council, given your familiarity with your own policies. So again, please take a few moments to read it if you want to, because I appreciate there's a lot to cover today.
Thank you. Yeah, in looking at policy IN2, that's specific to wind energy. NPF4 has more of an emphasis on renewable energy more widely, which is covered in our policy IN1. So these things need to be looked at, in conjunction with each other, and also with the supplementary guidance that we have as well. I do know that this isn't an application under the Town and Country Planning Act, and it's for the Scottish ministers to make. I mean, if we're looking at the sort of policy 11 and the sort of landscape and visual impacts, there is some similarity where we're looking at the extent to which, and this is in policy IN2, the extent to which the landscape is capable of accommodating the development without significant detrimental impacts. Now, there is a difference in point E2 where you have to accept that there are some localized or some impacts, and I know Mr. Bell pointed to the onshore wind policy statement at 3.6.1, where this will change the landscape, but development of this type was always going to change the landscape. It's not it's not anything new, I don't think, that we're looking at, and again, I suppose it kind of goes back to the point that we were discussing before about looking at sort of addressing to the nth degree. There always has been I suppose a a notion that the landscape will change. These effects are assessed as part of the landscape and visual impact assessment, and conclusions are drawn on that there. So I wouldn't say there was a great deal of difference between, if we're looking specifically at point E2 in terms of the landscape and visual impacts between policy 11 and policy IN2.
And thank you. And the kind of the same point, picking up on what Mr. McTeers said there for the applicant, please.
Thank you. I think Mr. McTeer is quite fair in the position that, you know, a number of the considerations in these policies are reflected in NPF4. I think that is correct. Where there are differences, I would say, are, as I've highlighted, the spatial framework approach that is the foundation for IN2 is no longer in NPF4, and in IN1 there's reference to tourism. There's now no longer reference to tourism impacts in policy 11, which probably reflects the continual finding of the government and through decision making on that topic, in terms of there not being any significant adverse effect on tourism economies. I think one of the big differences is in terms of the now specific direction in policy 11 to consider the contribution of the development insofar as significant weight to that matter in considering the specific impacts, and that is probably the big difference in the policies.
So on that point, in terms of the support that policy IN2 gives to wind energy, and on that point around that the significant weight that NPF4 introduces, can IN2 can that support essentially be kind of dialed up to recognise what NPF4 states? So it's not a question of what the policy wording is specifically, but a question of kind of that overall planning balance that's taken against it. But again, being mindful that policy isn't everything in this case, obviously.
I think we need to be careful not to put into a policy something that is not there. Case law is very clear on that in the Tesco case. And whilst there is reference to the benefits, there is a clear difference in the direction of the matter of weight. And I think that's a significant one between the two policies.
And you mentioned the spatial framework there, Mr. Bell, and that's on, I think it's page 68 of the LDP, which mirrors that in SPP, as you would expect. Can that be kind of set aside without any knock-on effects for other any other LDP policies, as far as you're aware? Again, council would be able to clarify that point.
I think this particular development doesn't contravene any of the spatial framework principles in terms of the group zoning, so it would be satisfactory in that regard. So there's perhaps a sort of academic point. Where I think the issue bites properly is if the council is saying that the adverse effects on the local landscape area are considered as one of the impacts in the context of the lead policies IN1, IN2, then that will go to a significant difference between the applicant and the council, because thus far in this discussion, the council has avoided all reference to the second limb of policy 4 that we're about to come on to. So if the council is advancing its case on the basis of controversy with the local landscape area, and that's engaged by the policy IN1 or IN2, then that is I would say, the nub of the policy issue.
It's my next set of questions, so it'll lead on very nicely. But before I ask, I should just revert back to the council to see if there's anything else that you'd like to pick up, or in terms of what Mr. Bell's just said.
Well, Mr. Bell mentioned the change with regard to weight. Well, you've got to remember that both IN1 and IN2, the policies do set out that the council will support wind energy proposals, I mean, that clearly is seen that they will give significant weight to the gains from such proposals. So I'd submit that there's certainly no incompatibility between policies, the IN policies, and policy 11, and I would, which is obviously the legal test, but I would say that there's no inconsistency as well. On the issue of spatial framework, and I'm sure we're going to come on to that when we're particularly looking at policy NE2 and policy 4. The NPF does set out a framework of where it considers developments acceptable and not acceptable, and it's the council's position that as we come on to look at policy 4 and NE2, that policy 4 actually strengthens the protection to be given to the regional scenic areas in this case, and it is clearly a very important policy. Bring this proposal, standing that a large chunk of the evidence, obviously, that we heard was in relation to the impact on the regional scenic area. But that's what we're obviously going to come on to that in a moment in the discussion. But my conclusion is, I'd say that there is no incompatibility here, and there is no inconsistency here between the IN policies and the policy 11.
I think that provides a very neat link to look at policy NE2 and its relationship with policy 4 of NPF4. So I'm interested again in that point around kind of emphasis, but also its particular requirements. So I suppose that it begs the sort of direct question: if the integrity of the Thornhill Uplands RSA was found to be affected by Sanquhar 2, would that still comply with policy 4? So I'm looking at the kind of national development aspect is to be classed as, assuming the national development is classed as more than of local importance. Well, that's a question in itself. But does that satisfy the policy test? I think there'll be a divergence of views here. But if I could ask Mr. Bell to start with that question, please.
Thanks, sir. I think our position is the development can comply with policy 4. The applicant's position in the evidence was that there would not be an adverse effect on the integrity of the RSA. So that would satisfy the first limb of policy 4. And as I set down in my evidence, if it was found that there was actually an adverse effect on the integrity of the area, then it would be a question of looking at the level of benefits that were offered by a proposal and whether they outweighed. And in this case, the benefits are of national importance. Therefore, should it be necessary to go on to deal with the second limb of policy 4, then the proposed development could satisfy the policy in that regard. And if one looks at the wording of policy NE2, there is no reference to the matter of integrity. And the way in which the policy is formulated is very different to that of policy 4 and NPF. And there is simply no balancing mechanism in terms of the threshold of benefits that NPF4 references. So my position would be, if I was asked the question, is this policy compatible and in lockstep with NPF4, my position would be no.
Thank you. And the council, please. So obviously, Mr. Armstrong, you've alluded to a somewhat different interpretation there. So I shall hand over to you, and then when Mr. McTeer is appropriate. Thanks.
Yeah, if I can start on that, yes. The council's position is that this strengthens the protection to the RSA. And if one has in front of one the NE2 policy, which is on page 51, CD 901, and policy 4, one can see the wording in policy NE2 says that proposals may be supported where the council is satisfied in relation to the points. So it may be supported. We now have in policy 4, it will only be supported where. And again, we can look at what was set out in the SPP and compare what was the earlier policy guidance from the government, but I'd submit that this is clearly a stronger support for protection of local landscape areas. You've obviously heard the evidence in relation to the council's position on this proposal affecting both the integrity of the area and the qualities of the RSA and the sea change that we suggest would occur as a result of this development. On the balancing point, well, again, my recollection of the evidence in relation to policy NE2 was we did discuss the balancing point, and the evidence there was that, well, of course, it's got to be balanced. Policy NE2 has got to be balanced with the support in IN1 for renewable energy developments. Say policy 4 D2 sets out, as Mr. Bell's already referred to, that any significant adverse effects on the integrity of the area are clearly, so there's got to be a clearly be outweighed by social, environmental, or economic benefits of at least local importance. It's not saying that the threshold is local importance. It's still providing a sort of weighing up evidence of the impact in relation to the landscape area and what the benefits are. That doesn't materially change the position from what it was before on the balancing exercise. But I'd submit the clear emphasis of policy 4 is to give greater protection to local landscape areas. And this may well tie in with the reason why the NPF doesn't provide a spatial framework, because it sets out in the key policies in this document what areas should be protected and what areas are suitable for development. With that introduction, I'll hand over to Mr. McTeer.
Thank you.
Not a great deal more to go on top of that, sir. Without running at the risk of repeating myself on my previous remarks to do with policy 4, unsurprisingly, there is a difference between ourselves and the applicant on this particular issue, and that mostly boils down to whether you agree that there are significant adverse effects on the regional scenic area. I have highlighted that both the case officer and the council's landscape architect in their responses both there had been adverse effects on the integrity of the RSA, and that's obviously a sort of key area of disagreement, bearing in mind that the decision is going to be taken in the round on this one, and it's for the Scottish ministers to make.
So, if I may, just listen to that debate. And we're going to come on to the onshore wind policy statement as a separate topic, but I do think it's important to read paragraph 3.6.2 of that document. And in short, I disagree with what Mr. Armstrong's had to say, Mr. McTeer's had to say in its entirety. The whole point is that the position has changed. We can see in 3.6.2 of the OWPS that the revised draft NPF4 signals support for all forms of renewable, making it clear that LDP should seek to realise their area's full potential for electricity. So where the only areas where wind energy is not supported are national parks and national scenic areas. Outside of those areas, so that includes your RSAs, the criteria for assessing proposals have been updated, including stronger weight being afforded to the contribution of the development of the climate emergency, as well as community benefits. That, it seems to me, is a clear support for the position that Mr. Bell has taken. It certainly runs contrary to the argument that there is enhanced protection, which I think is what the council was suggesting.
Thank you. I mean, I'm clear on your respective positions. I don't know if I need to ask anything further on that particular point, but Mr. Armstrong and Mr. McTeer, I don't know if you wanted to come back. You're welcome to on that point.
Sir, I don't think it back on that, because we're obviously going to come on and look at that document in a little bit more detail in due course.
Yeah. Okay. Thank you. So, in terms of appreciating this isn't a decision to necessarily be taken in accordance with the local development plan. But a question kind of for the council, I suppose a kind of an acid test for the LDP is whether you envisage NPF4 having any bearing on how wind farm decisions that you take or recommendations that you put into energy consents, for example, how those decisions may be taken by the council, whether that's because of kind of policy differences or matters of relative weight because of any kind of shifting emphasis, or is it more a case of business as usual to a large extent?
Well, sir. Obviously, the council will have regard to the amendments to the Act in relation to considering if there's any incompatibility. But perhaps have a hand over to Mr. McTeer on that.
I can really only sort of comment on my own sort of views on this going forward. It's obviously, you know, we're in the middle of transitional arrangements for this, and obviously there's you know, with respect to the council, there's you know, I have other colleagues in development planning and development management, you know, to go forward with this. The NPF4 again, just it obviously needs to be read alongside the development. They're both there. They're both material. I think I maybe alluded to earlier on in terms of policy 11, where we were sort of discussing wind farm development. I did note that there was the inclusion of things like repowering and extending, which is something that's you know, as a planner looking at these things, it's always nice to have a wee bit more clarity in policy terms. Yeah, it's something that we can. I don't think there's anything in NPF4 that's going to fundamentally alter our decision-making approach to developments of this type. There's nothing that's you know, wanting us to put down the LDP and you know, look at NPF4 with any more emphasis, while LDP2 still it's still in play.
Okay, thank you. And just to conclude this part of the agenda, back to the applicant, do you have any comments on that, on what you've just heard there?
Yes, sir. We take the view that NPF4 has to have a new bearing on decision making. There's been a clear shift of emphasis. As the government puts it, there's unprecedented challenges in terms of the global climate emergency, and the planning system is to be reactive to that. I would say, you know, if anyone listened to the debate in Parliament, the planning minister said this is the biggest change to the planning system since the 1947 Act. And there's a clear direction through Policy 1 and Policy 11 to significant weight, two elements of weight coming to bear on decision making. So to say it's business as usual, we say it cannot be the right approach. It doesn't, of course, act as a trump card for all applications. That would be an absurd proposition. But we say that there has been a rebalancing of the planning system, which decision makers now need to grapple with and apply. Thank you.
Thank you. Okay, I think that brings us to the end of item 3 on the agenda. So thanks for your input into that. It's a prime opportunity to take a lunch break as well. So I would say if we could have an hour, or I'll tell you, could we round it down to 55 minutes so we start at night around 1:30, so we don't lose track of time. So if we can all be back for 1:30, please, we'll be launching straight into item 4 on the agenda. I don't think this afternoon will take as long as we've spent on matters this morning, but we will see how we get on. So again, you can mute yourselves and turn your cameras off, and I shall see you at 1:30. Thanks very much. Okay, welcome back, everybody. I shall just wait until I can see everybody on my screen. See everybody rapidly appearing. And good afternoon, Mr. Brown. It's the first time I've seen your face on this particular occasion, so thanks for joining us.
Yes, good afternoon, sir. Thank you very much for agreeing to defer the start of this session to 10:30. Should that have been required, that was appreciated.
Problem. It was a safe margin, as you can now see. Okay, I think that's everybody. Yeah, Mr. Ford, sorry, before we start.
Thank you, sir. I said I would look at that section of my statement during lunchtime. You are quite right, sir. One of the words is incorrect, okay? It's not, it is necessitate. The word necessitate should be deleted in that sentence. So it should read, SS2 sustained the previously stated view that this does not exclude consideration of wider grid issues and the problems arising. Okay,
so it does not exclude rather. Okay, yeah, that makes sense. So I'd understood the point as you'd explained it to me. I must admit, I read it again at lunchtime. I thought I still don't quite understand what you said there, but no, that's fine. I probably didn't help by pointing to the wrong word. There we go. No, okay, thank you.
That's fine. Thanks very much. The general point is that the energy can't be used. That's the reason.
Yeah, no, I understand the point. Yeah, that's great.
So,
thanks.
You. Sorry about that, sir. I think it came out of the editing process. Probably my fault.
No, no problem at all. No, as I say, I was glad I asked anyway, because it was understanding the point that's important. No, that's helpful. Thank you.
It's good that it confirms your detailed reading, sir, as well.
Yeah, let's take that from it. That's good. Okay, so we'll move on to item 4, please. And this is where we're going to look at the onshore wind policy statement. So now what I'm keen to discuss here are the kind of differences of opinion expressed in hearing statements over the kind of direction of travel or the underlying sentiment of the updated onshore wind policy statement, which was published in December. Now, I want to focus first on the 20 gigawatt ambition as set out on page 6 of the document. So thinking about how challenging the ambition to have a minimum installed capacity of 20 gigawatts of onshore wind by 2030 may be. Now, Mr. Bell, you've outlined your position and you've commented on the makeup of kind of pipeline projects in your table 3.1 in your hearing statement. So could I just ask you to kind of outline what, in your view, makes the 20 gigawatt ambition ambitious?
Thank you. I think, firstly, in terms of setting the scene for that target, in my hearing statement at paragraph 244, so that's 2.4.4, NPF4 refers to making significant progress by 2030. So that date is important, and that links to the target. At 2.5.4 in my hearing statement, that references the statement of need around the national development, where there's reference to a large and rapid increase in electricity generation required. And in the onshore wind policy statement itself, paragraph 3.1.2 sorry, that's a wrong reference. Within the onshore wind policy statement, there is a key reference to page 49 to this. It says deployment of onshore wind is mission critical for meeting our climate targets. And the further reference is paragraph 1.3.1 in the onshore wind policy statement, where the government says, with regard to the 12 gigawatts of onshore wind to be developed, it is vital to send a strong signal and set a clear expectation on what we believe onshore wind capacity will contribute in the coming years. And we know from NPF4 that we talked about this morning in terms of national development status, what that means, and then policy 11 in terms of the contribution of any single development contributing to that target. So in my table, I set out generally the material that's already in the table in the onshore wind statement, but flagged up a number of the caveats that the government puts on it in terms of the long-standing government position that not every development that is consented will progress to implementation, because there'll be various issues that will prevent that from happening. And the matter of duplication, where there will be some schemes that are going forward, say for a tip height increase, the likes of Limekiln, for example, or Cairndewey is one that goes to inquiry later this week, that is in the consented basket, but it's also a scheme that's in the system, so to speak. So there are some duplications like that. And then there will be other reasons why development cannot necessarily proceed. For example, if the tip heights are consented at 125 metres, but there's no application for a tip height increase, that development will probably not progress. So the government recognises that although if you add up the figures in that table, it comes to 20 gigawatts, that does not mean that there is a ready pipeline that can be developed and we can easily meet that target. I do have some comments on Mr. Ford's position, but very happy to call a halt there if you wish to give you from other parties.
Yeah, thanks, Mr. Bell. I will hand over to Mr. Ford in a moment and to kind of consider the same point, and then we can I can come back to you once you've heard what Mr. Ford and potentially others have said. I think that might be helpful. So on that note, Mr. Ford, in 3.3 of your hearing statement, you set out how the 20 gigawatts compares to current operational and kind of pipeline projects, and concluded that the ambition is easily within sight. So it's kind of the same point. Could you just kind of give us a bit more detail to kind of support that view, and then we'll open it up a bit further.
Sure. Well, the obvious observation is the numbers I've given there, which is there's 8.7 gigawatts of existing capacity operational, and the pipeline is there. I've got 11.3 gigawatts, which actually does give you the 20 gigawatts ambition. I can quite understand why Mr. Bell wants to kind of point to the fact that not all wind farms that are consented get built, because it essentially undermines the need for, if you like, more consenting. That's an obvious self-interest position. And one of the kind of questions that digs into that is also, why don't these wind farms get built? Is there something wrong with them? Have they been, wrongly formulated by the developer in terms of the way they've been put forward, or is there some other problem with it? But overall, it's very clear that the numbers do simply add up. I mean, actually, it was quite striking when you read it. You go, wait a minute, that equals 20 gigawatts. It's as simple as that. So it's very clear that I'm sure there'll be other consents applications coming forward, and I would sympathise with Mr. Bell's position in terms of accepting that not all of those existing 11.3 gigawatts in the pipeline will actually be delivered and completed. I mean, I accept that broad point, but I think where we're going to differ is the fact that it's very clear that, and moving on to paragraph 3.4 of my statement, is that, and we touched on this earlier on this morning, there is an awful lot of capacity in the repowering of existing wind farms. And the numbers that we presented in the original hearing session back in October 2021 actually showed what the general conversion level is for repowering of wind farms, and that's generally something of the order of 45-fold, basically. Now, I have to say, not all existing sites is appropriate to repower and increase the capacity by that amount, but nevertheless, the draft onshore wind policy refresh statement back in 2021, late 2021, gave a capacity coming on stream that needing repowering in the next few years as being 2.5 gigawatts, and that means that if you apply the 4 to 5 fold increased capacity, you comfortably get to the kind of pipeline size that's stated in the onshore policy refresh. It's reasonable to assume that some of those 11.3 gigawatts in the current pipeline will actually be consented and built. I don't think we can take the view that none of them will be consented and viewed. But my view is that the shortfall will be made up by repowering that can come forward in the next few years, basically. So, I mean, it is striking that actually it's quite a comfortable target, you know, we'll come on to other aspects of this, no doubt, in a minute. But it is comfortably within the target that they've set. It's actually very easily achieved. It really doesn't need to go on to. We don't really need to be moving on to new virgin sites, and only, if you like, under very carefully considered situations, because it's fairly obvious that repowering existing sites where there's an established use is a less detrimental effect than going on to new sites like this.
Okay.
Thank you.
Thank you. So in terms of just taking the breakdown at its kind of face value, presumably one of the pipeline projects it's quoting within that makeup of, I think it's 19.9 gigawatts it totals. One of those projects is Sanquhar 2 wind farm. That's
right.
Okay. So I'll come back to you, Mr. Bell, in a moment, because I'm mindful that you had more to say, and obviously things will have cropped up from what Mr. Ford's just said there. But Mr. Ford, before we move on, so you've pointed to 3.4 of your hearing statement there. So just going back to that, in there you go on to say that the real question is whether the proposal represents the best choice from a kind of a large pool of projects to fulfil the overall ambition.
Yes.
I suppose my question is that a valid approach that I could take or ministers could take? So in wind farm inquiries, the point is often made to me that it's not a beauty contest. It's not a case of we're comparing that site over there with this site over there and the best one gets consent. So my question, I suppose, is should it not still be the case that every scheme gets assessed on its individual merits?
That's right. That's formally the process is that each site has to be assessed on its own merits. But one of the things that we touched on this morning was this concept of the right development in the right place. And in a sense, whilst I wouldn't describe it as a beauty contest, there is a sense that overall, the decision-making process should aim to minimise the overall adverse effects, if you like, collectively. So in that sense, I do think it's legitimate to say, do you know what? There are alternatives to this site elsewhere which have less environmental effects. Now, I appreciate we don't have a comprehensive assessment system, and unfortunately, people like you are stuck in the position where you have to measure each case on its own merit. But nevertheless, we are aware of the background and the standards that are being applied across the board to all these proposals. And by definition, it must be self-evident that repowering or life extending or expanding wind farms and existing sites are much more likely to be less environmentally adverse than a brand new wind farm such as this proposal.
Thank you. So on that note, before I hand back to Mr. Bell or Mr. Hardy, I just ask if the council would like to add anything at this point. I think that was a no, Mr. McTeer, but your microphone wasn't on.
No, we don't have very much to add to this other than noting the commitment, and as the policy statement says, it's a strong signal and a clear expectation as to what's coming forward.
Okay, thank you. Okay, Mr. Bell, please. So quite happy for you to pick up what you were planning to add before, but also obviously we've then progressed a little bit further. So happy to pick up whatever you want.
Thanks, sir. I just wonder if I could start with a question through you, sir. Mr. Ford has again re-emphasised the importance of repowering. I just wonder if I could ask him, since the last session of the inquiry, how many repowering consents has the Scottish Government issued?
I would need to go and look at the data to answer that question. I don't have it readily to hand.
Do you know the answer, Mr. Bell?
I don't think there's been any repowering consents, but happy if Mr. Ford wants to check that.
There certainly has been repowering consents. I'm aware of 2 or 3 around here, and certainly applications coming forward.
Just the names would be fine for the moment, and we can move on from that.
The onshore wind policy statement names Tangi Wind Farm.
No, that was issued a number of years ago.
Sure.
It was just in the last 18 months.
Hatshore Hill is a
again that's
consented
over 18. That's over 18 months ago.
Okay.
It's just since the last session of the inquiry. Happy to move on from that.
Yeah.
I think in terms of the suggestion that it's a self-interest position that I have, that there will be elements of duplication and other points like that with regard to the consented capacity, is simply not my position. It is the Scottish Government position as set out in the footnote to the table in the onshore wind policy statement. The second point I would make is, has just been touched on, this is one of the schemes in the pipeline. Thirdly, an important point to note is that the target is a minimum. It is not an end in itself. It's very clearly stated that the 20 gigawatts is a minimum capacity that the government is seeking. And one of the new policy aspects that's become clearer through the draft energy strategy that we touched on this morning is the role of expanding the energy generation sector. And page 8 of the draft energy strategy makes it clear that the government is seeking to export electricity to neighbours, supporting jobs in Scotland and the decarbonisation ambitions of our partners. So there's a reference to then the 12 gigawatts of onshore wind as part of wider ambitions for 20 gigawatts of additional low-cost renewable generation capacity by 2030. So it's not simply we get to 20 gigawatts and that's it. It's not simply indigenous supply for Scotland or the UK. It's a much broader global proposition.
20 gigawatts needs to be delivered or not, which we obviously covered in my statements, but that it's obviously beyond the terms of Scottish Government to be able to provide the capacity to allow that to happen, because it's a reserve matter and it falls ultimately under Ofgem and the electricity systems operator. But the general trend is actually that there is no more connection and transmission capacity to provide for onshore wind between Scotland and the rest of the UK. There are no other connections to export electricity other than to the rest of the UK, and the prospect of those happening is almost negligible.
Putting that point to one side for a moment, the 20 gigawatt ambition is still very much before us. So aside from, and we've noted, we talked earlier about what NPF4 says in Policy 11 about transmission capacity and connections. So you've discussed the role of other technologies recognised in the onshore wind policy statement and in NPF4, but does that alter anything in terms of the ongoing role of onshore wind? Because that 20 gigawatt target is specifically related to the onshore wind energy form of renewable energy, as opposed to other alternatives. So is that still clear cut in that regard?
No, it's not. And again, if we go back to paragraph 1.2.3.
Sorry, say that again, Mr. Ford. Which paragraph? 1.2.3.
1.2.3.
Yeah. Okay.
It there sets out the criteria that will be used to judge whether or not the 20 gigawatts ambition needs to be delivered, essentially. And it sets out three tests. The first is what the other generating technologies and innovations deliver in terms of alternative sources of energy. Secondly, it sets out the test of decarbonising the rest of society. In other words, in the original hearing, I just referred to whole system perspective in terms of energy, which included heat, transport, and industry. In other words, the bits that are not currently using electricity. So all of those all of the rest of the parts of society beyond the immediate consumption of electricity. And I set out in the previous sessions how we actually already really have enough capacity to deal with those, at the moment and coming on stream. One of the big changes in terms of since the previous hearings is that in terms of other generating technologies, is that the amount of offshore wind energy coming down the pipeline has jumped up substantially since the previous hearings back in October 21. And that is because the seabed leasing auctions that were run earlier last year under the ScotWind option were actually originally only expected to deliver 10 gigawatts of energy. They've actually leased seabed for 28 gigawatts of energy. So that's a substantial increase, which is, far exceeds the 20 gigawatts capacity. So in a sense, there might need to be a balancing between going offshore and coming up and the onshore energy.
So, sorry to interrupt you there. So are you seeing 1.2.3 as a kind of qualification of what the ambition below it then sets out? Is that correct?
Yes, it's whether this test needs to be met or not. Okay. Now we don't know what the answer will be in time, but it's very clear that the other technologies now are racing ahead in terms of capacity, and therefore there isn't the need to do this. The other thing about this is the speed at which we convert the rest of society. We've already mentioned this morning that electricity is almost all decarbonised in Scotland. And the question then is, how do you decarbonise the rest of society? Now, in the whole system energy calculations I gave you back in October 2021, I put the estimate in terms of the Scottish Government's estimate in terms of the total requirement for whole system energy at 17.5 gigawatts, which was the number then. That comes from the Scottish Energy Strategy 2017, which is based on the energy consumption and the energy consumption across the board for Scotland in 2016. We'll come to the energy strategy statement later on, but it doesn't give the same numbers in this. It actually refers straight to the Scottish Energy Hub, data hub. And having looked at the numbers in there recently, the overall level of energy consumption through electricity, heat, transport, and other sources has fallen back in the last 3 or 4 years to 16.6 gigawatts. So quite a substantial reduction, something like 5%.
So this is that's one of the factors that get picked up in 1.2.3 in terms of that qualification.
Yeah.
Mr. Bell, on that point about 1.2.3 kind of qualifying the ambition, do you agree with that? I think I know what you're going to say, but could then you say a little bit more as to why?
Yeah, I simply don't accept that. The planning policy for this development, the key planning policy is policy 11. And that states that development proposals for all forms of renewable, low carbon, zero emission technologies will be supported. And in the onshore wind policy statement, paragraph 132, in a box in bold, the emphasis could not be stronger. A minimum installed capacity of 20 gigawatts of onshore wind in Scotland by 2030. This policy statement, which is weeks old, sets a new ambition for the deployment of onshore wind. And we know that onshore wind is mission critical, that specific technology. And for the first time ever in Scotland, we have a technology specific target for onshore wind. So to say that that's qualified and actually it's easily.
So Mr. Ford's not making this up. It's clearly there in policy.
Can I say?
Sorry, hang on just a moment. Sorry, Mr. Ford. You can go to Mr. Ford, then Mr. Hardy. Can I bring you in after? Okay, thank you. Sorry, Mr. Ford.
Can I take you, sir, to paragraph 1.3.1, which refers to the Scottish Government's agreement after the Scottish Parliament elections. And you may be aware, sir, that there was an agreement between the two parties in power to deliver 12 gigawatts. There is a sense that this is saying that effectively delivering this extra 12 gigawatts or getting to 20 gigawatts was really a hangover from that political agreement. But that obviously predates the offshore wind leasing options. And realistically, my reading of the onshore wind policy statement generally is that they feel a bit more politically attached to that rather than to any particular need to deliver more onshore wind energy as such. So,
arguably, though, I would just say on that point, ministers are entitled to state whatever policy they wish for whatever motive, and far be it for me to question that.
I would fully endorse that, sir. I quite understand that. But there is a sense in which they may politically feel as though they're on a hook in terms of that particular commitment. And when you look at the overall need in terms of what Scotland needs in terms of energy, there really isn't any need to deliver this 20 gigawatts completely, because there's plenty of offshore wind energy and other sources as well.
Okay. Sorry, Mr. Hardy, I did say I would come up to you and I almost didn't.
Just to be very short, I mean, I find it amazing to hear Mr. Ford interpret these documents in the way he has. Nothing short of that. Policy 11 sets out in principle, as a matter of principle, that development proposals for all forms, and this is onshore, nothing to do with offshore, all forms of renewable, low carbon and zero emission technologies will be supported. And that includes wind farms, to take Mr. Campbell's point, that includes repowering, extending, expanding and extending the life of existing wind farms. So in principle support for onshore renewables, wind farms, repowering, etc. The 20 gig is a minimum, that is not a ceiling. And it seems to me that that is really an end of it. And what Mr. Ford has to say is just making more difficult than something which is really quite straightforward needs to be.
I want to, thanks, Mr. Hardy. I want to move on in a moment. Mr. Ford, have you got any kind of concluding points?
Yeah, the point of what Mr. Hardy is referring to is all renewables. Okay, it doesn't say that means we need onshore wind farm. All renewables includes offshore wind.
But in terms of what the onshore wind policy statement says, and my questioning around the 20 gigawatt ambition, that's focused on onshore wind specifically.
But Mr. Hardy's directing you back towards NPF4 and policy 11. Policy 11 is about all renewables, not just about onshore wind.
Policy 11 is specific. A1, wind farms. So all forms of renewable, low carbon and zero emission technologies will be supported. That includes Roman 1, wind farms. They are onshore.
Several others as well.
Okay, I'll just ask us to catch breath there. I've got what I need from that discussion, so thank you. So on the let me just check my questions to see whether I've got any more on that particular point. Yeah, so I just wanted to ask Mr. Ford actually. So in paragraph 3.9, you've suggested that the ambition's not a commitment. It comes at the end of that paragraph. So the 20 gigawatt ambition, you're kind of focusing on the words there, into the precise word that's used. And so my question is, does the use of the word ambition indicate a lack of kind of conviction, or is it possibly recognition that it will be difficult to achieve, hence why it's an ambition rather than a commitment? Can it be looked at the opposite way?
Well, my reading of it certainly was that ambition is like a hope or something like that. In other words, it's something fairly ethereal and nothing particularly fixed. Whereas if we look at the offshore wind, for example, the capacity that's now offshore wind, which is about 38 gigawatts altogether, those are formal commitments because they're leasing the seabed. And those projects are, much further on than a kind of ethereal concept of an ambition. Those are committed projects now.
But as an ambition, it's still a minimum. It's still a minimum ambition. So it's not we hope to get there, but it's okay if we don't. They kind of say, well, we hope to. I suppose my reading of it was something a bit stronger than how you've interpreted that. So just wanted to kind of explore that.
it's because of that paragraph 1.2.3 and those qualifications about the other alternatives, basically. The third thing that I haven't mentioned previously is that there are also other issues within the onshore policy refresh, onshore policy statement itself, about other issues about delivery, such as barriers to connections or barriers to capacity and delivery and all that kind of thing. So there are other issues as well as those two main issues within that decision process. So, for example, we're not suggesting that all environmental considerations, for example, local environmental considerations, should be completely set aside.
No, that's fine, Mr. Ford. No, I understand. Okay, so unless anybody would like to add anything further on that particular point around the 20 gigawatt ambition, I think we've covered the ground pretty well there. I'd like to move on to the second part of this agenda item. So, Mr. Brown, you've been waiting very patiently. Thank you. You'll get your opportunity now to contribute to the hearing. So I'll be kind of asking the airport, or yourself, Mr. Brown, on behalf of the airport first. So you've outlined in, I think it's paragraph 8 of your hearing statement. Just get that in front of me. You need to have a bit of a swap around the papers. So in paragraph 8, you outline what you consider to be kind of fundamental changes in the onshore wind policy statement, and I'd like to look at some of the points you make in a bit more detail, please.
Yes.
So, starting with points 1 to 3, is this the first time these points have been kind of recognised in a policy document? And well, that's the first part of the question. And then, kind of, are these matters which were kind of in? I don't think these are matters that were disputed by the applicant in broad terms, in terms of things that can be brought to the fore as part of this inquiry. But can I just have your thoughts on those 2 points, please?
Yes, so certainly so far as point 1 and 2 are concerned, then the airport's position is yes, there's a very clear statement now in the policy documents about both of those aspects. So far as the third point is concerned, I appreciate that there were references in earlier policy documents to the fact that there were broader impacts on aviation operations, but I think it is of note that the references in the draft to the particular forms of impacts have been removed. And I would contend, sir, that is a recognition that there are more disparate impacts, such as were explored during the inquiry regarding impact on instrument flight procedures, instrument landing procedures, systems rather, VHF radio. And then, of course, there's the cumulative impact, which has really only started to be considered in the context of this inquiry and the Clockery inquiry, which preceded it.
Thank you. So then, in terms of points 4 and 5 in paragraph 8 of your hearing statement, so you've made comparisons with the consultative draft version of the document, and obviously you pick that up in number 3, which you've just mentioned there, and it extends through to number 7 too. So my question or my challenge is whether or not that's a meaningful comparison, and by that I mean a draft document for consultation purposes could say theoretically almost anything, but until it's been finalised, it's unlikely it would be given much weight. So, what should I take from a comparison between a consultative draft document and then the finalised version of it?
Well, sir, so far as the draft document is concerned about the transitioning of costs, the point was made that reference to the transitioning of costs, I would submit, was actually drawn from earlier policy statements in Ops 2017 and Mr. Wheelhouse's letter, both of which were referred to in the closing submissions for the airport, paragraph 126. And I think it is of note that there was reference in the draft to the transitioning of costs, but by the time we got to the final draft policy, the direction of travel on that had changed, and so there is now no reference to the transitioning of costs to the aviation sector. So it's not quite so that there was a change between the draft and the Ops 2022 document. There's actually been a change in the policy, which was set out in Ops 2017 and referred to by Paul Wheelhouse in his letter, and Ops 2022.
I'll come back. I'll give the applicant a chance to kind of comment in a moment. And just before I do that, just finish this part of in terms of my questions. So on point 5, again, paragraph 8, where it says a departure from that one there, and it's around the kind of question of transparency and the absence of this word in the final updated onshore wind policy statement. So you've essentially outlined in paragraph 4 that this should be seen as a green light from the Scottish Government that confidentiality clauses or non-disclosure agreements can be used. I'm not sure that was being challenged by the applicant, and the applicant can clarify, but that the applicant's challenge was that you cannot insist upon that approach. Is that, well, I should perhaps ask Mr. Bell to answer that rather than you, Mr. Brown, initially. Mr. Bell, would that be a fair kind of?
I'll do the airport aviation related matters. So that's absolutely.
Of course, absolutely. Sorry.
Yes.
Okay, that's correct. Right. Okay. So no, that's just helpful to as we progress. So I suppose my thought then is, does the onshore wind policy statement kind of take us any further on that point around kind of transparency and fairness? So if I need to assess the fairness of the mitigation measures being sought, and how can I do that if what's being sought is not transparent? You know, how can I? Does that make sense as a question? So if it's not, if it's going to be a fair process and it's come before myself to assess, can I assess it if it's not transparent? It's Mr. Brown first, please, and I'll ask Mr. Hardy to come in.
Yes, thank you, sir. Well, the issue there, sir, is that how can the Scottish Government say it's appropriate for the work of Onward 2030 to be conducted privately without it having to be made public? In regard to the commercial sensitivity of the information which has to be exchanged to facilitate the discussion, and at the same time say to the airport that it's not appropriate, that it also seeks the same protection in a discussion with the applicant. And on the question of fairness, so this was covered in the airport's earlier submissions. The process also has to be fair to the airport. Fairness is not a one-way concept. Here, why should the airport be forced to publicly make this information available in a way which doesn't and hasn't happened with any other air navigation service provider?
Mr. Hardy, would you like to comment on kind of my question and also Mr. Brown's response?
Yes, just a few points, if I may. I mean, a general observation is that it again feels difficult to understand how the airport can read these documents in the way that it articulates its case. It does seem to be from a sort of parallel universe. That's the first general point. Secondly, considerable submissions were made in closing, and we stand by all of those. I think we're dealing with what this document has brought over and above that. And the third point is I would start actually with policy 11 of NPF4, which deals with aviation. So it's on policy 11E, and then it's 4. So if you could just look at that, that's on internal page 53. So in addition, project design and mitigation will demonstrate how the following impacts are addressed. And then 4, impacts on aviation and defence interests, including seismological recording, but that has to be read subject to the text at the end. In considering these impacts, significant weight will be placed on the contribution of the proposal to renewable energy generation targets and on greenhouse gas emission reduction targets. The 4th point then, and that neatly leads into the wording of the OWPS. And if I was to paraphrase that, what the applicant would say is, you know, what's been happening has been okay, but it's been haphazard. But what needs to happen is something quicker and something which is lower cost to the industry. We can see that from 6.1.2. So bespoke solutions have been deployed successfully, fair enough, but there's a however. We've got to do something different. The pace of deployment necessitated by the climate emergency means we must find a way to alleviate these impacts in an effective, efficient and timely manner. It's also important that solutions are cognizant of the cost of deploying renewable energy, particularly given the need to focus on both security of supply and low cost generation, given the current international and economic situation. So costs for the for the generators has to come down, and that's because of the climate change objectives which have already been set out. The 5th point is this: there is the Aviation and Renewables Collaboration Board to be set up. And when you go to Annex 7, so that's on page 72, you'll see that the formal functions are set out at the bottom, so working towards coexistence, sharing of experience, and then 3, cost-neutral mitigation, so developing a strategy and identifying responsibilities of stakeholders in the delivery of a series of cost-neutral mitigation solutions to be implemented by 2030. These solutions should not result in profit from mitigations, and the process of having a mitigation should be fair and non-revenue generating. It should also meet the needs of both onshore wind and aviation, both civil and military requirements. Now, this is within the terms of reference of the board, but the advice very clearly is what we're striving towards is fair and something which is non-revenue generating. Clearly, that is the principal allegation which is levelled at the airport. You've got the all of the accounts and so on, and the profit that's being made. And then over the page, page 74, that reference to non-disclosure agreements, I'm afraid, it's been taken out of context by the airport. That comes with that point 4 comes under the heading of rules of engagement for the board. So when the board is talking and they're having their think tank sessions, then there'll be respect for NDAs, but that's within the context of those discussions. That absolutely does not require or legitimize the process that the airport has been seeking to foist on the wind energy industry. And so any suggestion that that somehow has hardened support for deals being done around the back and for nobody else to understand what they're like in the planning system, I'm afraid is the opposite of the position. So I hope I think that's 6 points that I want to make, and I hope that covers the ground, sir.
Thank you. Yeah, so you've helped me sort of neatly link into kind of one of my own questions there in terms of thinking about the purpose of Annex 7, because I was conscious that, so I think Mr. Brown, so in terms of point 6 in paragraph 8 of your hearing statement, that comes back to the point around transparency too, and that observation I think is made in the kind of context of Annex 7. Is that correct?
Yes.
I didn't see who said yes to them. Was that Mr. Brown, or was that or was that you, Mr. Hardy?
I think that was Mr. Hardy, sir, because I couldn't reach for the mic button quickly enough. Yes, there's certainly reference to cost neutral, sir, but the issue about that is, what does cost neutral mean? Someone will have to bear the cost of it, and the other issue is that it's the work of the Onward 2030 group is to be carried out, and no doubt there'll be an opportunity to explore the issues. But the reference to a cost-neutral solution would presuppose that there is a solution, and there was reference earlier to the fact that the aim of an aspiration of the government is to find regional solutions. And the question is there a regional solution to some of the issues which will arise? And all of that will have to be explored during the work of the board. And the question will no doubt arise about whether there is a solution, if there's not a regional solution. If there's not a regional solution, and there have to be bespoke solutions, how are they to be funded? And as I said, someone's going to have to pay the cost of that. And how can they be cost neutral for anyone if someone has to pay the cost of them? So all of that has to be explored in more detail, I would submit, sir. And it may well be that the work of the board, or Onward 2030, is that there is no cost neutral solution to this, and that's the reality of it.
So taking some of those fundamental changes which you've outlined in paragraph 8, kind of derived from the content of Annex 7, it's important that I understand properly kind of what the purpose of Annex 7 actually is. So does it need to be, or is it intended to be kind of taken into account in individual decision making, or is it purely outlined in terms of reference for a more kind of strategic oversight of the issue by the Onward group? So that's Mr. Brown first, and I'll come to Mr. Hardy.
Well, sir, I would suggest that it is more than just terms of reference for the group, in as much as it does set out the vision for the group. It sets out its formal functions, which are to work towards coexistence. The detail of that is given. So when these sections are properly considered, it must be a statement of policy that that's where the Scottish Government wishes to end up through the work of the Aviation 2030 group, or the Onward 2030 group.
I suppose, is it something that can be readily applied to individual development management decisions, or is it something bigger?
It's something bigger, sir, undoubtedly, and of course that's why the submission ultimately is, and from the airport, both in its closing submissions and in its submissions on Ops 2022, that until that something bigger is worked out, there is a risk that following the applicant's position in this case will cut across the work of that group.
Thank you. Mr. Hardy, please.
Yes, 2 points in response. The policy is set out in Chapter 6, and it's quite clear from paragraph 6.1.7 that Annex 7 is the terms of reference of the group. That's exactly what the wording says. We don't need to go beyond that. It tells you what the group is going to do. The second thing really is not to lose sight of the fact that this scheme is to be determined on its merits. And we've heard from the airport just there about regional solutions and so on. The regional solution, of course, in this case was a wind farm tolerant radar, which is already being paid for, and for which the airport has a war chest from wind farm contributions. So this scheme And the arguments put forward by this scheme are, well, let's have a look at the actual impacts that are going to be caused. Does it consume its own smoke? Yes, it does. Thank you very much. So nothing that's been said, takes away from that position.
Okay, thank you. I don't have a great deal more questions, to be honest, on this particular point. I'm mindful, unsurprisingly, this has been focused at Mr. Brown and Mr. Hardy, but I just wanted to check if any other parties wish to contribute on this particular point. Seeing lots of shaking of heads.
No, thank you, sir. No, thank you.
Okay. So I suppose, Mr. Brown, I'll give you a kind of a chance to sum up in case I've not given you the opportunity to kind of say everything that you wanted to. So to kind of conclude and pull together what we've discussed. So what should I be taking away as the kind of main substance of the onshore wind policy statement in terms of aviation matters?
Yes, the substance of it, I would submit, sir, is that there is a change of direction. We have the removal of, there's more balance given to the interests of the aviation sector. There has been the removal of the reference to transitioning of costs to the aviation sector, which appeared in earlier policy documents. It's quite clear from OPS 2022 that the Scottish Government recognises the issues are difficult. There are technical issues, there are cost issues, there are questions about who should bear the risk, sir, and that's a clear acknowledgement. And my submission is that the Onward 2030 group should be left to do its job without the risk of its work being cut across by the outcome of this inquiry. And just one final point, Mr. Hardy referred there to the regional solution being the installation of the wind farm tolerant radar at the airport. I would submit, sir, that it's quite clear from the evidence that, and from OPS 22, that the impacts go beyond radar. And so that is not the regional solution and could never be the regional solution. And of course, that takes no account, even if that was to be considered a solution, it takes no account of the risks associated with maintaining that solution for the life of the proposal.
Okay, thank you. I'm happy to leave that there, unless Mr. Hardy, there was anything burning that you wanted to.
Just one half sentence, that is in relation to those other matters. Of course, there are things, so the VHF and so on, but that was all dealt with. All the points raised by the airport have been mitigated in our case. We consume our own smoke, so that doesn't take the airport anywhere in our submission. Thank you.
Okay, thank you. Right, I don't have any more questions under item 4 for anybody, so I'd like to, unless anybody thinks I've missed something incredibly obvious and I need to go back to it, you might be able to capture it in the next item anyway, if that's the case. So in item 5, so this is really an opportunity to kind of really bring together our discussion so far on NPF4, the onshore wind policy statement, and the LDP, but also bring into the mix the draft energy strategy and just transition plan, if that would be helpful. So if I can perhaps somewhat crudely sum up the kind of positions of parties as I understand them. So the applicant's view is that taken together, policy alters the way in which the planning balance is to be reached for onshore wind proposals. So that doesn't dictate the outcome, but the relative weight to be given to the benefits should be increased in that wider policy context. The council is probably more a case of kind of business as usual, but so policy seeking the right development in the right place, and the matters relevant to that assessment are broadly unchanged from kind of SPP, which was carried through to the LDP, so they're satisfied that compatibility is there. For Stop Sanquhar 2, we're seeing more of a pulling back from onshore wind through a shift in policy emphasis away from it, and this has weakened the case for this wind farm. Perhaps don't need to summarise the airport's point, because that's more of a focused discussion. So I won't do that now. Firstly, I'd like to know whether that was a very rough summary and very short, but was it fair? And I'd like to hear from all of you on that point, and then I'd like to hear any kind of concluding comments that you would wish to make to kind of pull this together. So I'll start with the applicant first, just to see. First of all, my first question was that a fair summary before I miscategorise what you've been saying all day so far?
Yes, it was, sir. I've got a couple of concluding comments, if you want me to add them.
I'll come back to that in a moment, Mr. Bell, if that's okay. Yeah, I'll just check that I have summarised it acceptably for everybody first. So, Mr. Armstrong, Mr. McTeer, were you satisfied with kind of how I summarised that in a few words?
Yes, sir. In relation to the LDP and the NPF, I think I would emphasise. Well, I do emphasise, and Mr. McTeer emphasised the important, we say, change in relation to the protection to the RSA and the heightened protection given to that. So I'd say that is one thing where, particularly in this case, where the RSA and the effects on it are so critical, that is a change and goes against permission being granted here.
Yes, you're quite right. You did make that point very clearly, so thank you. And then for stop Sanquhar 2, were you satisfied with kind of how I crudely summed up your case?
Yes, sir. In short terms, we think that the requirement for onshore wind is nothing like what it was before, and that the policy has shifted away. There's a general shift across NPF4 on many areas that mean that different aspects of this either need to be re-evaluated if it's going to be consented, or need more consideration. And obviously, in terms of the onshore wind policy statement, it's very clear that there's a policy option to get out of the 20 gigawatts, sorry. And that's because that there is lots of other alternatives. The primary need now for Scotland to address climate change is not about more decarbonisation of electricity, it's about decarbonisation of the rest of society. And that requires other things other than more onshore renewables, for example. In terms of renewables generally, there is now a substantial volume of offshore wind. The Scottish Energy Strategy draft gives that number at 38 gigawatts of options that are coming down the track for delivery pretty quickly by 2030 and shortly after for the remainder. So there are a lot of options, and the policy priority in terms of adversely affecting the environment because of onshore wind farms is now shifted.
Thank you, Mr. Ford. That was helpful in that I was just about to say, well, I think as I'd asked you to speak last and confirm your kind of position, I'd ask you to kind of summarise your overall position yourself, make any final comments first. So is there anything else you'd like to add before we conclude? And then I'm going to open it up to the council and then Mr. Bell and Mr. Hardy to finish.
I think I've summarised it, sir, but one thing I would add is that we've obviously in the earlier hearings and in the submissions and so on, we've obviously raised this issue and put this issue squarely on the table about how the energy from this wind farm will be used. And the essential position is that the energy, because of the oversupply situation in Scotland and the lack of transmission capacity going southwards, there is no ability to use the energy coming from this proposal. And therefore, the balancing process that is now required in NPF4 11E is to measure all the various impacts against the net contribution. Because the net contribution is effectively near zero, by definition, that means that all those other environmental effects should be the determining issues here. This is something that we've had on the table and that the applicant has effectively declined to respond to. They will give their own reasons for doing that, but my sense is actually that the reality is that they don't have an answer to it.
Okay. Thank you, Mr. Ford. Then Mr. Armstrong and Mr. McTeer, is there anything else you'd like to kind of add, just in summary and to conclude?
So I think we've really set everything out today, in particular in Mr. McTeer's statement. I should just draw attention to one minor error in relation to the statement that we should have perhaps picked up earlier, and that is at paragraph 17.
Sorry, Mr. Armstrong, I didn't catch the reference.
Sorry, paragraph 2.17 of the first response. There's a reference to the Langham Hills regional scenic area, and it should be the Thornhill Uplands regional scenic area. And I think for completeness, the DPEA reference on the front, where we've got WIN-170, it should be 2006 rather than 5. But they were just two minor sort of typos that we had noticed. But otherwise, the statement really fully sets out the council's position on these matters.
Thank you, Mr. Armstrong. I appreciate as well, this isn't the only hearing of this type that you'll be having over the coming days and weeks. So I understand the typo completely. Thank you. Okay, and then I'd like to give the final word to the applicants, Mr. Hardy or Mr. Bell. Would you like to make any kind of concluding remarks on that?
It's just both of us. I'll start, if I may, with a couple of points. And it's really the council's reading of the documents, which I find impossible to accept. And I think 3.6.2 of the onshore wind policy statement is the best place to look, because the government has written a suite of documents which actually work together very well. Written at the same time, they're intended to be consistent. So what we're told by the authors is that the revised NPF4 is out, signalling support for all forms of renewables. And then the bit that I've read out before, the only areas where wind energy is not supported are national parks and national scenic areas. So outside of those areas, criteria for assessing proposals have been updated, including stronger weight being afforded to the contribution of the development to the climate emergency, as well as community benefits. So a couple of points really from that. Policy 11 in the NPF is being described. And what that is saying is that you get support for onshore wind. You've got to subject to the other criteria. But the only area where that support does not occur is under policy 11B. So development proposals for wind farms in national parks and national scenic areas will not be supported. Mr. Ford's shaking his head, but that is what the policy says in black and white. And therefore,
read the whole document.
I've read the document, Mr. Ford, lots of times. When you read the documents, the idea that it's business as usual, which is the wording of the council, but other than it's got harder in locally designated landscape areas, is an extraordinary proposition in our submission. You cannot rationally read these documents and come away with that view. I think the other thing to say from paragraph 3.6.2 is that something has changed, because it tells you in the wording at the end of that paragraph, outside of these areas, the criteria for assessing proposals have been updated. So there's been change. Updated means refreshed, but including stronger weight being afforded to the contribution of the development to the climate emergency. So whatever was there before, whether you were applying significant weight, whether you were applying substantial weight, whatever articulation of gravity you were giving those benefits, stronger weight is being given by these documents. So that tells you the change that this document is trying to bring about in very clear language for onshore wind. And then the second point really is in relation to Mr. Ford, who I mean, he sort of says he put me lay down a challenge that the applicant has failed to deal with these points. We've listened very carefully to what Mr. Ford has to say, and we've only dealt with those points which are relevant. And just listening to him, it is black argued as white, I'm afraid, in terms of these documents. So we've engaged with the points which are considered to be irrelevant. Those that we haven't dealt with, we simply disagree with as being relevant at all. So those are my two overarching points, and then I think Mr. Bell's got.
I think just to finish, again, from my planning perspective, to add what Mr. Hardy has said, on the basis of Policy 11 giving in principle support, we're taking into the minimum target, and the last point I would make is about that stronger weight. We get direction on that from not only Policy 1 in terms of the climate and emergency, but also Policy 11 within the wording there. That's all I wanted to add. Thank you.
Okay. Thank you very much. Okay, well, that brings us to the end of the agenda, and I don't have any further questions for anyone. So thank you for your contributions. Now, Mr. Campbell,
You've not said that you want a written summing up from this session. I sense that you do. I sense that you don't, but I'd like to check it with you.
I don't. Thank you. No. I don't need that. Thank you. So what I'll do now. So in terms of next steps, so ministers have asked that I submit a supplementary report which will take account of the matters we've been discussing. Obviously, now in terms of timescales, I've been asked to try and do this by the end of February. So that'll be my main focus over the next 3 or 4 weeks. So no, I don't need any further submissions from any parties. If anything was to arise, such as new policy documents that come in from the side that we haven't captured today, then I would be leaning towards further written submissions rather than a further hearing, unless there was something particularly significant that we weren't expecting. So does anybody have any other questions in terms of next steps and procedure which they wish to raise? No.
No, sir. Just to
Well,
say,
in which case, thank you. That's the end of the session then. So I'll close the inquiry, and just thank you all again for your input today and for your patience with me as well. So thank you very much.
thank you very much.
Thank you.
Bye.
Thank you.
Bye.